Mr. Romero, are you at the main jail? Can you hear me? Mr. Romero at the main jail. Okay, we're trying to get a hold of the audio people, and I haven't gotten a response. It's 8:29. The camera's out at the main jail, so I don't know if there's something that we can start at North Broward, Conti, or Paul Ryan. So I don't even know if you can hear me, Mr. Romero, or who's ever at the main jail. Hi.
Hello, good morning.
The camera's out at the main jail. I've been trying to get a hold of the audio people. I've texted them, called them, emailed them. So we might just start with your people. How many people do you have there today?
I got one domestic violence and one refusal.
Okay, who's your domestic violence person?
Leroy Williams. Leroy Vincent Williams.
Okay. All right, good morning, Mr. Williams. How are you?
Good morning, all right.
All right, we have Mr. Reedy who's here in the courtroom today. You're in magistrate court, first appearance court. Today we're going to determine if there's probable cause. You have the right to remain silent. Anything you say or do can and will be used against you. You have a count of a violation of probation for a misdemeanor. You do have a hearing that's going to be set on a violation in probation within probably the next couple of days in front of Judge McHugh. So you'll probably be going before Judge Cohen. Says here that you did commit the offense of battery. You failed to report to the office. 2 visits, so there's a no bond hold. So, Mr. Reedy, is there anything you'd like to add? Okay, all right, thank you very much. Good luck to you, sir.
The refusal that I had is Monqueef, Fabian, page 13.
M-O-N?
Correct, yes.
Okay, Fabian, page 13, you said, I'm sorry?
Yes, ma'am.
All right. Fabian O'Neill Moncrief. He has grand capious felony, grand theft in the 3rd degree. He has a hearing date next Monday. Court does find probable cause.
Your Honor, he's aware of his court date.
Okay, and he voluntarily refused?
Correct. I believe last time he was here, he asked to waive his appearance.
Okay.
But it is count 35.
Okay. All right, so I guess that's it for today. Thank you.
Well, this morning, yes.
Yes, thank you.
Okay.
See you soon.
Bye-bye.
Bye-bye. All right, who do we have at Paul Ryan?
We have this Webb, man, Your Honor. Page 1. Sarah Webb.
All right, I can't hear you. What'd you say the name is?
Last name is Webb, Your Honor. Webb, W-E-B-B. Shakira.
I don't have that on the docket. Does anybody have that?
What's the last name? Williams?
Webb.
Webb.
Ma'am, say and spell your.
Webb, W-E-B-B, as in
That's
boy.
what I thought. Yeah.
Webb is on domestic.
Felony?
Felony.
They're not doing felonies.
We're not doing felony. She shouldn't.
Well, we are doing felony domestics if they come here per Judge Tudor.
No, she's on the
But she's on
felony docket.
felony docket, so we don't have a file. And you got people? No.
I don't have paperwork, so.
She's,
Cause she's not, she's,
All right,
her
so
paperwork should be gone to the felony.
they gotta get her over to Judge Cohen by.
hold on. I'm calling Judge Cohen. Hold on. What's your first name, ma'am?
Jakira, J-A-K-I-R-A.
Yes, hi, this is Judge Malika calling from First Appearance Court. How are you? Good. I know that Judge Tudor wanted me to do first appearance for the domestics if they came to the courtroom. The problem, however, is we don't have the paperwork. And are you saying there's an issue, Sheila, from confinement?
I'm sorry.
Are you saying there's an issue, we can't magistrate her if we don't have the paperwork here?
Well, we don't have the
Lord,
paperwork
no.
here. She should be TOT'd over to go see the felony judge this evening.
What's TOT?
Transported, I'm sorry.
Okay. Okay, so I don't know what you want to do. Would you like to speak to Judge Cohen and ask him? I have no paperwork. Well, I don't know. Do you have it? Webb, Shakira.
She was already put on Cohen's docket, so she should be following, she should be seeing everything.
Yes. Yes, but hopefully I'll get it 7761. Thank you. Bye-bye.
That's it, why is it the deputy court, they shouldn't have put it.
Well, this is the thing. If we get domestics here, we're supposed to do them.
Right, but she's not here, the deputy just happened to pull her file. But paperwork, docket, everything except for Judge Cohen.
I know, but the problem is Judge Cohen's 11, and this is what we were trying to avoid, is when people mistakenly come here. So maybe we can go get the paperwork from Judge Cohen. But let's see what how Judge Cohen wants to handle it. All right, ma'am, have a seat. We'll be back with you in a moment, okay?
Thank you.
You're welcome.
And also, Judge, if that's the case, then instead of rushing to do that.
What do you mean rushing?
Meaning to do her this morning, because she's being ad charged with some not in custody cases that's coming to second magistrate anyway, today. So they can do all of that, and then if you just wanna do it all at once on second, then they can.
So she does have ad charges this
She has
afternoon
ad charges that's placed on her to go to second magistrate
for here today.
for here.
That's not Greg, sorry. Hi. So I'm just gonna send the person back and then we'll deal with them this afternoon, but can someone bring it to magistrate court directly to 4155? Awesome, thank you. Bye-bye. Okay. All right, good morning, everybody. You're in first appearance magistrate court. Sorry about that. There was some technical difficulties with the main jail camera. Today, you're going to be informed of the charges, and we're going to determine if there's probable cause. Today is not your trial day. Please do not talk about the facts of your case. Everything's being recorded. You have a right to remain silent. You have a right to an attorney. There's a public defender at the main jail. I don't know who it is. And we have Mr. Reedy here to my right in the courtroom. If you have a private attorney, please let me know when you step up at the podium. It is 8:45. Sorry again for beginning late, but there was some technical difficulties. We're going to call some cases out of turn, but I am going to go to Paul Ryan for a moment. Is there a Shakira Webb there?
Yes, Your Honor, she's here. Step up.
All right, Ms. Webb, they're bringing me your paperwork from Judge Cohen from his courtroom. So we're going to reset you for this afternoon at 1 o'clock because it's also my understanding that you do have some ad charges, okay?
Do you mind telling me the ad charge?
I don't know what they are, ma'am. We'll tell you at 1 o'clock, okay?
Okay, thank you so much.
Thank you for your patience. All right, so we're going to call a couple cases out of turn. Junie George, page 11 out of the docket.
Mr. Junie George, come on up, please. He's approaching, Judge.
Okay.
And the volume is a little bit low again today.
All right, well, I keep trying to reach out to Craig and I never get a response back, so let me try him again. Well, let me try to raise the volume myself. Is that up?
Is it a little better? A little bit?
Can you hear me, sir? Are you Mr. Junie George?
Yes, ma'am.
Can you hear me okay?
Yes, ma'am.
Does my voice sound low to you?
No, ma'am.
All right, thank you. Page 11 of the docket, Junie George.
Judge, I know count 3, I believe, is a municipal ordinance case. I don't know if it's from Fort Lauderdale.
All right, let me check. It is from, we'll have to wait for Mr. McLaurin. So when he gets there, please let me know.
I will.
All right, so we can handle this matter. So let me just put a note here. James Dario, page 18.
Mr. Dario, come on up, please.
Okay, good morning, Mr. Dario. You have burglary of an unoccupied conveyance unarmed. Need to talk about bond. Count 2 is petty theft. Second degree, first offense. No bond attached to that. Count 3, sir, is loitering or prowling. There's no bond attached to that. You do have an out-of-county hold for a misdemeanor where you do have a no bond hold. Court does find probable cause. Court is going to order, sir, no victim contact, direct or indirect, with the alleged victim in the case with the initials TB. And I want everybody to listen up in the jail. When I say there's no contact, direct or indirect, if you need me to explain this further when you come up, just let me know and I have no problem letting you know. No contact, direct or indirect, means no contact in person, calling, texting, writing, nothing on social media whatsoever, not even liking, disliking, commenting to anything, and no contact through third parties. And in this case, sir, it's with the alleged victim with the initials TB. Do you understand?
Yes, Your Honor.
All right. So, State, what is it that you're seeking?
Your Honor, I'm seeking a $2,500 bond, noting that,
On count 1?
yes, the VOP warrant is, the no bond warrant is for his failure to appear at a VOP out of Collier County, and now he's before the court committing a felony offense while out on probation.
All right, Mr. Romero.
Judge, we're going to be asking for a $1,000 bond. Mr. Dario is 26 years old. He just got employed at a place called Tats and Tacos. He's been there for about 6 months. He's a server. He makes about $6 per hour plus tip. He lives in Wilton Manors. He lives with a roommate. They share the expenses. His portion is about $600 per month. Right now, the only people he's going to be able to contact are his parents to help post his monetary bond. Considering this is a third-degree felony, Judge, also he has an out-of-county hold, I believe, from Collier. So we'd be asking you to consider a $1,000 bond on Mr. Dario's behalf.
$1,500 bond on one, the rest remain. No victim contact. Thank you, sir. Good luck to you.
Thank
Next
you.
one, you're welcome. Next one's going to be Marvin Carter, page 17.
Come on up, Mr. Marvin Carter. Mr. Marvin Carter, come on up.
After Mr. Carter, we're taking Todrick McNair on page 18 at a turn.
Yes, Judge.
Excuse me. Thank you. Thank you.
Before you were judge, nobody said that.
Yeah, I know. They did. How are you this morning? Good. All right, are you Marvin Lewis Carter?
Yes, sir.
All right, sir. You have obstruction of highway, no bond attached to that. You also have failure to report, vacating your permanent residence. State?
Your Honor, I'm requesting $2,500 bond based
On
on the
count
nature of
two?
the offense. Yes.
All right, 25 on count 2.
$25?
100.
Oh, 25.
It's failure to register.
Yes, Judge.
Hello. Good morning. You don't have to be sorry. No big deal.
Judge, we're
Life
gonna be
happens.
asking the court to consider a $1,000 bond on count 2. Mr. Carter is 62 years old, been living in our community his whole entire life. He gets his income is from Social Security. It's about $700 a month. He lives in Hollywood with his sister. His sister doesn't work, and basically he's like kind of supporting the household. So right now, financially, his family is not in a position to help post his monetary bond. He believes maybe that his sister could come up with $100. So that's the nature of why we're requesting a $1,000 bond on count 2, Judge.
All right, $2,000 bond on count 2. We'll leave one at, there's no bond required. Next one, Todrick Lee McNair, page 18, please.
Judge, he's approaching,
Okay?
and he declined the services of public defender.
All right, Mr. Todrick Lee McNair, you know if you can't afford an attorney, one will be appointed for you, sir.
Yes, ma'am.
All right? Keeping that in mind, you still want to, you still don't want the public defender?
Okay, what'd you say?
Keeping that in mind, you still want to represent yourself, sir?
Yes.
All right, sir, you have a possession of cocaine, $1,000 bond. Count 2 is purchase cocaine, $3,500 bond. The court does find probable cause. Can you afford the $4,500 bond, sir? You have any response?
No, ma'am.
All right, can you afford the bond?
Well, I make $1,200 every month because I get a check for my disability. I don't know if I can or not.
All right, state, any further?
No, Judge.
All right, what's his prior record?
Your Honor, from what I can tell, mostly trespasses. I know he's, I don't know, he was arrested April 6th of this year on a failure to appear. February 26th this year on a failure to appear. Last year he
For
was
what?
arrested on a failure to appear.
Trespass?
Mostly trespass in the past. I know at least on one occasion he's gone through Judge Leonard Rim's MI division.
Oh, he has.
Yes.
Was he represented by the public defender? Hello, how are you? looking something up, sir, okay? Please be patient.
Does not appear as though we represent Mr. McNair, nor does it appear we ever have.
Okay, all right, this is what I'm gonna do, Mr. McNair. I'm gonna set bond on count 1 at $1,000, and count 2, I'm gonna set it at $100. So you have $1,100 bond total, okay? So try to contact your family member.
I did. What'd you say, miss?
Did you contact a family member to see if they could help you bond
Oh,
out?
not yet. I gotta make a phone call. I got the white paper and the yellow paper.
Do you have the person's number on you, or is it in your phone?
Yeah, it's in my head. I got my sister's number in my head.
Okay, sir. All right, so we'll see you in a couple days if you can't bond out, okay?
Yes, ma'am.
Thank you.
Our Spanish interpreter is here, Judge.
All right, well. So we have to take the Spanish interpreter now and go off the regular detox list docket. So let's change gears again. Tell me who's here for the Spanish interpreter.
On page 2 of the docket, Your Honor, Mr. John Cardenas.
Mr. Cardenas is here present, Judge at Maine. Come on up. Ven aquí, por favor,
All right,
señor.
let me find out who else is for the Spanish interpreter, because I want Michelle to pull them out so we can have a little bit of rhythm going here. So who else do we need for the Spanish interpreter?
Let me inquire. I was just working on that.
Anybody at North Broward need the Spanish interpreter?
No, ma'am.
Thank
no one
you.
else at Maine, Judge, requires Spanish interpreter.
All right, anybody at Conti need a Spanish interpreter, please? Oh, we finished with them. Anybody at Paul Ryan need a Spanish?
No, ma'am.
All right, and
No,
what
ma'am.
is that lady's name there at Paul Ryan?
Dips,
Spell
page
the,
5, DEMPS, Your Honor.
all right, after the detox, we'll try to go to that one so you don't have to sit there all day, okay?
Thank you, ma'am.
All right,
Thank you.
so, Mr. Interpreter, if you could raise your right hand kindly. Do you swear and/or affirm to translate from Spanish to English, English to Spanish to the best of your ability?
I do, Ana. Give us an easy.
Thank you very much.
You're welcome.
All right, so we have, are you Mr. John Cardenas?
¿Es usted el señor John Cardenas?
Judge, he declined the services of public defender.
Okay,
Él
thank you,
declinó el servicio
Mr.
del abogado
Romero.
público. Gracias, señor Cardenas.
Are you Mr. John Cardenas, sir?
Señor, usted es el señor John Cardenas.
No escucho bien.
I can't hear well. ¿Es usted el señor John Cardenas?
Sí.
Yes.
Okay. Ask him if he can hear you okay.
¿Usted me escucha a mí?
Sí.
Yes.
Okay, good. All right, Mr. Cardenas, you are charged with 1 count of touch or strike battery, domestic violence.
Señor Cardenas es acusado de un cargo de tocar o lesiones, violencia doméstica.
No acepto los cargos.
I don't accept the charges.
Okay, I'm not asking him if he accepts them, I'm just telling him what he's charged with.
No le estoy preguntando si él acepta los cargos, simplemente le estoy informando de que está acusado.
This is first appearance magistrate court.
Esto es el Tribunal de Audiencias de Magistrado de Primera Comparecencia.
Today, we're just determining if there's probable cause.
Hoy simplemente se determina si existe motivo fundado.
Today is not his trial day.
Hoy no es el día de juicio.
Please do not talk about the facts of the case.
Por favor, no hable sobre los hechos del caso.
Everything you say can and will be used against you,
Todo lo que usted diga puede y será usado en su contra,
as this hearing is being audio and videotaped.
ya que esta audiencia está siendo grabada por video y por audio.
I was also advised that you declined the services of the public defender,
También se me informó que usted declinó los servicios o rechazó los servicios del abogado público.
and I'd like you to know, sir, you have a right to a court-appointed counsel today.
Y quiero que usted sepa, señor, que tiene el derecho a tener abogado nombrado por el tribunal para usted.
If you cannot afford an attorney, the court will appoint the public defender's offices for purposes of today.
Si usted no puede costear los servicios de un abogado privado, el tribunal nombraría el abogado público para que lo represente para la audiencia de hoy.
If you have a private attorney, please let me know.
Si tiene un abogado privado que lo esté representando, por favor, déjeme saber.
So for purposes of this hearing today, sir, do you want to still represent yourself and
Así que-
decline the services of the public defender?
Así que para la audiencia de hoy, señor, ¿desea aún representarse usted rechazando los servicios del abogado público?
No.
No.
No what?
¿No qué?
He wants to represent himself, or?
¿Se quiere representar usted mismo o quiere el abogado público?
Quiero el abogado público.
I want the PD.
Okay, Mr. Romero, he does want the public defender.
Señor Romero, él
So
sí
how
quiere los
much
servicios del
time
abogado
do you need
público.
to speak to him?
¿Cuánto tiempo necesita para hablar con él?
Couple minutes, Judge.
Unos minutos.
All right, so we'll just pass this case and we'll take someone at Paul Ryan. Go ahead.
Okay, Judge.
All right, Paul Ryan, let's call, what page? Mashonda Demps, Deputy, what page?
Page five.
Thank you, Deputy, I appreciate it. All right, are you Mashonda Monrique Demps?
Mishonda Monique Demps.
All right, ma'am, you are charged with resisting an officer or obstructing without violence. Court does find probable cause, bond set at $100. Mr. Reedy, Estate, do you have an offer? Does she want to resolve this case? Can she resolve this case?
Well, I think Ms. Demps might consider an offer if it involved the withheld adjudication, so she would not have a conviction on her record. She has no prior record from what she tells me.
Okay, State, what's your position?
That would be the state's offer, withhold.
All right, would you like to inquire?
Ms. Demps, if you want to enter a plea of no contest to this charge, the sentence that you would receive would be a withheld adjudication, which means you would not have a conviction on your record, and you would have to pay court costs. And the case would end today. Or I could ask the judge to release you on your own recognizance, and you can come back to court and fight the case. What would you like to do?
This is my first time, so I really don't understand.
Okay.
All right, so why don't we do this, Mr. Reedy? It doesn't sound like you've had an opportunity to talk to
No, I
Ms.
have.
Oh, you have?
But she's
Okay.
never been arrested before, so she's in a situation that's very unfamiliar to her.
I understand.
I'd ask the court to consider releasing her own recognizance.
I don't have a problem with that if she has no prior record.
Well, she says she doesn't. I don't hear anything to the contrary from the state.
Okay, ma'am, so I'll tell you what I'll do. Instead of you resolving your case today and giving you a withhold of adjudication, which means no conviction, and just the court costs, because this is your first time you've ever been arrested, the court will ROR you, which means release you on your own recognizance, but you're going to have to come back to court, and if you can't afford an attorney, one will be appointed. They'll send you a court date in the mail, but I do need to verify your address. It's 2408 Northwest 8th Street, Pompano Beach, Florida.
33069.
Yes, okay. All right, so if you don't get a court date in the mail within the next 2 weeks, go to browardclerk.org. It's the clerk of court here in Broward County, and put your name in. It has Mashonda Demps, D-E-M-P-S, and you'll see your court date. You can also contact the public defender's office if you don't get something, because if you don't show up, you're going to end up back in jail. They're going to issue a capias, which is another word for a warrant for your arrest, okay?
Okay, thank you, sir. Ma'am.
You're welcome. Have a good day. Don't worry about it.
Good luck,
Okay.
Mishonda.
All right,
Judge,
let's go
whenever
back.
we're ready on Mr. John Cardenas.
Sure. All right, thank you, Michelle, you're so welcome. All right, Mr. Cardenas, so you now have the services of Mr. Romero. You're charged with 1 count of touch or strike battery, domestic violence.
Señor Cardenas, ahora tiene los servicios del señor Romero. Es acusado de un cargo de lesiones y violencia doméstica.
Mr. Linder, what say you?
State is requesting $2,000 bond, no victim contact.
Señor Linder, ¿qué es lo que dice usted? La Fiscalía estará pidiendo una fianza de $2,000 y no tener contacto con la víctima.
All right, the court does find probable cause,
El tribunal sí dictamina que existe motivo fundado
and the court is going to order no victim contact, direct or indirect,
y también va a ordenar al tribunal que no haya contacto con la víctima, directo o indirecto,
and that is with the alleged victim,
y es con la alegada víctima,
with the initials AC,
con las iniciales A, C,
and that means, sir, no contact in person, calling, texting, writing,
y eso significa, señor, que no tenga ningún tipo de contacto con esa persona, ni por teléfono, ni por llamadas telefónicas, ni por texto, ni por escrito.
No contact whatsoever on social media.
Por medios sociales tampoco, ni en persona.
And no contact through third parties.
Y no puede tener contacto con esa persona a través de terceras partes.
Okay, so Mr. Romero, go ahead, sir.
Señor Romero, adelante.
Judge, in speaking with Mr. Cardenas, the $2,000 bond, which they suggested at this time, is reasonable. The only thing we're going to be asking the court to do.
Si pensamos que es razonable una fianza de $2,000, lo único que le estaríamos pidiendo al tribunal que pueda hacer, que hiciese,
We're going to be asking for a phone order so he can access his contacts to contact his friend to post his monetary bond, Judge.
estaríamos pidiendo una orden judicial para que él pueda tener acceso a su teléfono, para que él pueda contactar a sus amigos para que puedan pagar la fianza.
All right, so the court will grant your request for a phone order.
Entonces el
$2,000 bond.
Le otorga la orden judicial para que pueda tener contacto con su celular y una fianza de $2,000.
Thank you, Judge.
Thank you. All right, we have to take the detox people first, okay?
I came a little later this morning.
That's okay.
Too early,
All right, did you, what's the name and what page? I'll have Michelle pull it.
Dana Aiello, he's at the main jail.
Is there a Dana Aiello? All right, so let's take Ryan McRot. Page 18 of a docket. Ryan McRoot. Did you get this, gentlemen? I think that's it.
Thank you.
Do you need a moment to speak to your client, sir?
Oh, no.
Okay, because you can use Mr. Reedy's phone.
Talked to him last night.
Okay, just wanted to make sure.
Thank you, Judge.
You're welcome. All right, Ryan McRoot, page 19. Is that your name, sir?
Yes.
All right, good morning, sir. You have a charge of burglary, unoccupied structure, unarmed. We need to talk about bond. You have count 2, grand theft between $300 and $5,000, $1,000 bond set. Court does find probable cause. Court is going to order no victim contact, direct or indirect, sir, with the alleged victim with the initials PDN. Do you understand?
Yes.
Did you hear me say before what no victim contact, direct or indirect means?
Yes.
Okay, do you have any questions regarding what that means? No? Okay, good. All right, so State, what bond are you requesting on count 1 and any special conditions?
Your Honor, I'm going to be requesting $10,000 bond on count 1. I would note, even though he's charged with burglary of a structure, it does appear this is a residence, it's burglary of a dwelling. He does have outstanding warrants out of Pennsylvania for failing to appear in court, Your Honor, and I'm also showing not a long residence in Broward, so I am concerned about his ties to the community.
Okay, defense. Judge, in speaking with Mr. McRoot, unfortunately the $10,000 bond, which the state has suggested, is financially out of reach for Mr. McRoot. At this time, unfortunately, he is homeless. However, he is employed. He just found a job about 4 months ago. He's working at a restaurant called Vinny's by the Sea. He's a busser. He makes about $5 plus tip. There's really nobody he can call to help post his monetary bond. He does have a mailing address that he can provide the court, would be of his parents who live in Pennsylvania. You can get correspondence and future notices from them. But unfortunately, there's no one that's going to be able to post a monetary bond. So, Judge, we'd be asking you to consider pretrial release, Judge.
All right, burglary, unoccupied structure, unarmed. Court is going to do a $2,500 bond. Count 2, grand theft. Court's going to do a $1,000 bond, no victim contact. And, sir, there's no return to 108 and a half Commercial Boulevard, Lauderdale by the Sea. Thank you very much, sir. Good luck to you. Next one is Stephen Cyrix, page 22 of the docket.
Mr. Sirius, come on up.
Cyrix, I'm sorry.
Judge, he declined to serve as the public defender. He's proceeding pro se.
Okay. Okay, come on up, Mr. Sirius. Next one after this is John Matella, page 23, after Mr. Sirius. Hello, Mr. Sirius. How are you, sir?
I'm good.
All right, sir, you have petty theft, second degree, third or subsequent offense, $750 bond. Count 2, possess and or use drug paraphernalia, no bond attached to that. Count 3 is operating without a valid DL, no bond attached to that. Counts 4, 5, and 6 are probation violations. You're going to be held no bond. You are going before your division judge, Judge Michael Lynch, on June 5th, which is this coming Tuesday at 9 a.m. Anybody wish to be heard? Okay, court's going to make your bond on count 1, $749, sir. Luck to you. You'll see your division judge on Tuesday. Next one is going to be John Victor Metello, page 23 of the docket, please. John Victor Metello, and then after that is Andrew Solomon.
Mr. Mottola, come on up, please.
Good morning, Mr. Metello. You have count 1, retail theft, $300+ coordinate with others, $1,000 bond. Count 2 is possess and or use drug paraphernalia. There's no bond attached to that. The court does find probable cause. The court's going to order no return cert of a target at 3200 North Federal Highway in Fort Lauderdale. Do you understand, sir?
Yes, Your Honor.
You go back there, sir, you're going to be arrested, okay? So make sure you don't return to this target. All right, anybody wish to be heard on the $1,000 bond?
Judge, we're going to be requesting a phone order.
Okay, court will do a phone order, $1,000 bond. Thank you. Next
Thank you,
one
Judge.
is, you're welcome, Andrew Solomon, page 25. And after Mr. Solomon,
Mr.
we have...
Solomon is here present, Judge, and he declined the service of public defender.
Okay, and next one, Mr. Romero, is going to be Ramzi Hussan, page 26. Okay, Mr. Solomon, how are you today, sir?
Good morning, Judge.
All right, sir, you decline the services of the public defender?
I'm sorry, I can't hear you.
You decline the services of the public defender, sir?
Yeah, I'm planning on hiring a lawyer.
Okay. All right, well, just for purposes of today, you can use the services of the public defender.
For today, I can?
Yeah, you have to fill out an application, but it's just for today.
Okay, no, that's great.
What did they say to you?
I have, Judge, I'm doing an interview. He's gonna have to wait a little bit if he wants to fill out the paperwork.
Okay, so you want to wait a little bit and use them? Your bond is being posted, so the court does find probable cause.
I'm not quite sure what I want to do. That's the thing.
All right, your bond is being posted in any event, sir. So
Okay.
you're going to get out of jail. Is your address 821 Northwest 127th Ave, Coral Springs?
Correct. Correct.
All right, sir, good luck to you. The court does find probable cause, okay? Look for your court date in the mail. Hire a private attorney. Next one is going to be Ramzi Hussan, page 26.
He's here present, Judge, and he has private counsel, Mr. Amaro.
Hello, how are you?
Good morning, Your Honor. A.J. Amoroso on behalf of Ramsey Hussan.
Can you spell your last name again? I'm sorry.
A-M-O-R-O-S-O.
A-M-O-S.
Missing an O. A-M-O-R-O-S-O.
Okay. All right, nice to see you again, sir.
Nice to see you, Your Honor.
All right, are you Mr. Ramzi Hussan, sir?
Yes, ma'am.
All right, we have your private attorney here, Mr. Amoroso. You are charged with 1 count of robbery by sudden snatching without a weapon. I'm sorry, without a firearm or a weapon. Court does find probable cause unless I hear an objection.
No.
Okay, state.
Your Honor, I provided the court with and defense counsel with a supplemental report that gives a little bit more detail about this incident.
All right, well, hold on and let me read it since I just got it.
Okay, but also just to advise, so you know what you have, there's also a second report. He has a pending case, and I printed the court the probable cause for that case as well.
Okay. So we're just doing the 1 case today, but you printed me the second as well?
Well, I'm going to refer to it, so I just want the court to be aware of it.
Did you see these, Counselor?
I did.
All right, so give me 1 moment.
Allowed to speak?
Sir, you have the
No.
right to remain silent. Anything you say can and will be used against you. You have an attorney here today, so you might want to let him speak to you, okay? I mean, speak for you.
too, but I guess she changed her mind.
Can you give me one moment? All right. Okay, go ahead, State.
All right, Your Honor, I'm going to be requesting a $15,000 bond, noting and GPS monitor. Mr. Hassoun's priors include burglary, grand theft, petty thefts, stealing stolen property, false ownership info. My greatest concern, as you can see, Your Honor, he has a pending strong-arm robbery where the allegations, to a degree, mimic the allegations on the robbery before the court. That Mr. Hassoun approaches people under the guise of seeking money for transportation and then proceeds to rob them.
Okay, defense.
Judge, Mr. Hassoun's got a serious drug problem.
Can you hear your attorney, sir?
No, I can't.
I'll get a little closer to the microphone.
Can you do me a favor and call Craig and ask him if he can up the volume, please?
Judge, Mr. Hassoun has a very serious drug problem. What the state is requesting is not unreasonable. However, I know financially, for Mr. Hassoun, it is. Judge, I'm asking the court if the court would consider, instead of a $15,000 bond, a $5,000 bond, electronic monitor, custody, and I know, Ramsey, you're not going to want to hear this, custody to custody transfer to First Step Sober House, where he has a relationship with the program and the personnel there. And Judge, the only conditions that he should ever be on the street is either work, grocery shopping, medical appointments, and if necessary, although I know they have it on the premises, NAA meetings. And that should be the only reason why he needs to be out there. And that's what I'm asking of the court.
Well, at First Step Sober House, do they have the AA meetings there, or do they go to another location? Does anybody know?
They have him there, Your Honor. I'm sorry to speak. They have him there.
They do have him there, Judge.
They have him there.
Is there any time they're required to go off the facility other than maybe to a physician or something?
All I'm asking the court is, if it's a medical situation, the only reason he needs to leave First Step Sober House, Your Honor, is to work, medical, grocery shopping. I guess what I'm asking for is it level 2 or the highest standard of pretrial release with the electronic monitor and a straight custody to custody transfer from the jail to First Step.
Okay, state your position, your response, if any.
Your Honor, I'm still requesting the $15,000 in the GPS, and I hear what Mr. Amoroso is saying. I understand Mr. Hassoun has a serious drug issue. But my greater concern is with the citizens of Broward County, and now we have allegations that 2 separate people have been robbed by Mr. Hassoun, and I believe that's the greater concern.
Mm-hmm.
Judge, with the electronic monitor, we're going to know where he is at all times. And like I said, the only reason he needs to leave First Step is to go to work. I spoke to his employer yesterday. The job is still available to him when he
Where's
works.
the job?
Ramsey, what's the name of Brittany's business?
The job is literally on Cypress Creek and 31st. It's about 5 10 minutes away from the halfway house. And Your Honor, I know I shouldn't be speaking, but any crime I've ever committed
No,
in my
sir,
entire
don't talk about
don't
the
talk
facts
about
of
any-
the case.
Don't talk about any
We're
facts
just
of the
talking
case.
about your work, sir. So, can you tell me what his hours are, what he does?
Ramsey, tell the judge how often you work and what your hours are.
My hours are Monday through Friday, 9 a.m. until 7 p.m. I'm off on the weekends.
And what's the name of the business?
It's called Modern Health Benefits. I can give you guys the phone number. You guys can contact Kelly from First Step Sober House and anybody from First Step Sober House. All of them, you guys know them. They all know me. I need the structure. I need to be there. I've always been there on my own will, but me being forced to be there is probably the best thing for me.
Okay, this is what the court's gonna do. Court is gonna do a $7,500 bond, GPS level 2, custody to custody, to First Step Sober House. There's no return to I believe it's 1500 East Sample Road State.
That's
Yes, Your
correct.
Honor.
That's fine. 1500. No return, sir, to 1500 East Sample Road. It's where you were arrested, where this alleged incident occurred, I believe. Doesn't even say the name of this business. And you are, sir, to have no victim contact, direct or indirect, with the alleged victim in this case, with the initials VLC. Your attorney can give you, sir, the full name of the person. Okay, it's in the arrest report, huh?
Level 2, correct?
Yes. And the court is going to do a curfew, sir. $7:30 p.m. to, what time did he say he works?
What time do you start work?
I start work at 9 a.m. Obviously, I take the bus. I get off at 7 p.m.
All right, so we'll make it, how long does it take him to get back on the bus and home again?
Judge, in an abundance of caution, can we do it from 8 p.m. to 7 a.m.?
Well, yeah, just make sure an hour is sufficient.
That's why I'm giving him a little bit of a buffer.
Okay. All right, so we'll do it 8 p.m. to, we'll do 7 a.m., okay? All right, so court's going to also order that you follow any recommendations of First Step Sober House. That might even include a reduction in his work hours. I don't know if that's going to be feasible or something. If it isn't, then, you know, obviously you can go before his division judge, okay?
Perfect.
Thank you very much.
Thank you, Your
All right, Ms. Jackson, you had a
Ramsey, I'll
question
talk
for
to
me.
you.
Can I see the paperwork? 2,000. Well, I wrote 2,000 and then someone wrote 2,000 and 1,000. That's not my writing.
Judge, I'm heading up to your courtroom.
All right, hold on one moment. I would like to do the gentleman that's in the main jail there. So hold on, okay? All right, Mr. Cardenas, I don't remember. I have written in here 2,000.
Okay, they have 2,000. I had one, so I'll leave it for 2.
Okay, I wrote 2,000 and put my initials. All right, Mr. McLawrence, you have, who is it?
It's Junie George on page 11 of the docket, Your Honor.
Is she at the main jail?
He's here at the main jail with me, Judge.
All right, so let's do it with you and Mr. Romero. They are on one of our lists. Hold on, Mr. McLawrence and Mr. Romero, yes. Okay, well, you can make sure he doesn't leave. All right, just let me look at this. Give me 1 minute on this. Okay, so are you Junie George, sir?
Yes, Junie George.
Yes, ma'am.
All right, sir, you have possession of cannabis, 20 grams or less, $100 bond. Count 2 is drug paraphernalia, possess and or use. No bond attached to that. You do have a KPS misdemeanor trespass, $500 bond, which is an MO case. Anybody wish to be heard?
Yes, Your Honor. Judge, Mr. Romero and I spoke to Mr. George, and Mr. George indicated to us that he wants to resolve all of his cases. He also indicated that he's homeless, and he would like to get some assistance. We discussed the Henderson Centralized Receiving Center to him, and he told me that that's an option that he wants to take advantage of.
All right, if he wants to take advantage of it, I could have Michelle write up an order and do it where he can be released there by 9 p.m. He can be transported there 9 p.m. tonight. Is that okay with you, Mr. McLawrence, and you, Mr. Romero? Any objections?
Yes, Your Honor. Sounds like a plan, Judge.
All right, so Michelle, if you could do this for Junie George. All right, so he wants to resolve the case?
Yes, Judge.
All right,
Yes,
State.
Your Honor.
State's offered me withhold on both counts.
Okay, withhold on all counts, court costs of $308 on the possession of cannabis. Drug paraphernalia, I don't have to do court costs. And count 3, the trespass. I don't know where that, can you pull up this MO case for me, Michelle, please?
Judge, I have it. It's at a 7-Eleven located at 330 North Federal Highway in Fort Lauderdale.
Thank you, Mr. McLawrence, I appreciate it. All right, so, Mr. Junie George, you want to resolve your case today, sir?
Yes, ma'am.
All right, raise your right hand. Do you swear and or affirm to tell the truth?
Yes, ma'am.
All right, put your hand down. Is your name Junie George, George?
Yes, ma'am.
It's my understanding you wish to waive your right to a trial, sir?
Yes, ma'am.
Anybody forcing you to do this? And in other words, are you doing this freely and voluntarily?
Yes, ma'am.
Are you under the influence of any alcohol, drugs, or medication that would affect your ability to understand what's going on here today, sir?
No, ma'am.
All right, you understand that if you're not a U.S. citizen, a plea to this charge could result in deportation proceedings and affect your ability, sir, to remain in the United States?
Yes, ma'am.
All right. You agree not to go back to the 7-Eleven at 330 North Federal Highway, Fort Lauderdale, Florida?
Yes, ma'am.
You understand that if you do go back there, sir, that you will be arrested?
Yes, ma'am.
All right, understanding what I just explained to you, pleading guilty, not guilty, or no contest. Let me read the charges. Possession of cannabis, 20 grams or less, drug paraphernalia, possess and or use, and trespass, sir.
No contest.
Court's going to accept your plea, find that's freely and voluntarily entered. Court has reviewed the court file, finds probable cause for the plea. Court's going to withhold on each count. Impose court costs on the possession of cannabis of $308. On the KPS misdemeanor trespass, Ms. Jackson, the court's going to impose court costs of $78. You have 30 days to appeal the sentence of the court.
Andre Hicks?
Court takes judicial notice of time served. All right, sir, in the Broward County Jail. And Mr. George is requesting to go to the Central Receiving Center.
Correct.
Mr. McLawrence, you agree too? Just want it on the
Yes, sir.
record. Okay, thank you very much, sir. Good luck to you.
So Judge, I'll be coming up for the rest.
Okay, thank you. One on per defendant's request. Next one is going to be Daryl Giles.
Mr. Giles is here present, Judge, in Maine. Come on up, Mr. Giles.
Okay, here you go, Ms. Patrice. Thank you. Okay, are you Daryl Lamont Giles, sir?
Yes, ma'am.
All right. Sorry, you have a question, Ms. Jackson? Oh, okay, you were talking to someone else. All right. All right, sir. You have a possession of cocaine, $1,000 bond, count 2. It's a KBS misdemeanor. That is for a driving while license is suspended. Judge Hurley issued a $1,000 bond in December 2017. Court does find probable cause. Anybody wish to be heard with regard to the $2,000 bond?
Judge, in speaking with Mr. Giles, that's something that he's not going to be able to afford. He's 55 years old. At this time, he's self-employed. He does construction for a living. It fluctuates depending on a whole bunch of factors like weather and things of that nature.
What is it you're asking for, Mr. Romero?
Judge, I'd ask you on count 1, and speaking with him, release some ROR. I don't know if this is a residue amount. On count 2, though, Mr. Giles has asked me
Half
to
a gram,
right now.
0.05.
I'm sorry, I didn't hear
Half a gram, 0.05.
Oh,
0.5.
Judge, I don't know if the court would be inclined, based on that small amount, if you would consider an ROR or release Mr. Giles on pretrial release. But on count 2, he's also asking the court if you would consider resolving count 2.
State? Did you speak to him about the effect it could have on his felony case?
Let me talk to him right now.
Okay. Ms. Jackson, do we have a driving record on Mr. Giles? And then after this, we have the last person on the detox list is Justin Berry, page 27. Do we have any private attorneys? All right. All right, so Michelle, do you have their names pulled?
Yes.
Okay. Pardon? All right, I have no driving record for Mr. Giles, Mr. Romero. So State, do you have an offer? And you have to do a separate order, Mr. Amoroso. Okay?
Judge, he wishes to resolve the traffic court.
Pardon?
I was paid for.
The offer on
He
count
wishes to
2.
resolve count 2, Judge.
The offer on count 2 would be an adjudication time served.
Adjudication time served.
Your Honor, the state would not agree to outright release the pretrial on count 1. Mr. Giles has prior failures to appear and prior failures to comply with court orders.
Judge, I think he's, Mr. Giles, if we heard correctly, the state is indicating that they're objecting to pretrial release and that they've indicated that Mr. Giles has failure to appear. From what he's telling me, he's unaware. He never willfully failed to show to court.
All right, let's just talk about the adjudication and court costs. Is that something he'd be inclined to do?
He would, but Judge, my understanding is he
Adjudicating the court costs of what?
on count 2. But on count 1 also, he's wanting to know if the court is going to be willing to release him pre-trial release. If not, he's going to be here in custody. My understanding is it was a medical reset. He's been in already like 3 days, I believe.
Can he afford a $100 bond?
Can you afford a $100 bond?
I'll have to scrap it up, but I'm really looking for him to do an ROR.
I mean, you're going to be in here. How likely is it you going to be able to scrap it up, as you say, here in custody?
We can hear you.
What I'm saying.
So
I need ROR.
Judge, he's not going to be able to scrap it up using his terminology, Judge.
Also noting he's used aliases in the past, and as far as the representation that he's never had a failure to appear, he's before the court today on at least one.
Okay, does he have anybody that can pay? Mr. Romero saying he can't hear you. I think part of it is it's pretty noisy at the main jail today. I can hear it. So maybe they can lower their voices a little bit, Mr. Romero, and it'll be easier for you to hear us.
Thank you, Judge.
Thank you. All right, so,
Judge, I know, I believe from Mr. Giles, he's trying to recollect the instances potentially that he had maybe a failure to appear. I believe on one of them, he said he was, it was here in Broward.
Yes.
But he was actually in Port St. Lucie, I believe incarcerated, so he didn't willfully fail to show. So I don't know if maybe Mr. Linder, in referring to the failure to appear, is referring to that specific incident.
Well, if he's in jail somewhere else, technically, he's voluntarily absenting himself from the court, but we won't get into that. But Mr. Linder, what say you?
I take the same position. I mean,
Okay, I understand. All right, so this is what the court will do. Mr. Linder is doing an asking for an adjudication time served, $293 in court costs. I have no driving record, have no idea what the effect would be. He's going to have to determine if he wants to go forward with that, and also considering the fact that, you know, it could affect as a felony case. I don't know how many, you know, how much of an effect it's going to have or where he's at. The court is inclined to do a standard pretrial release, but have your client keep in mind, you know, that if he has a $1,000 bond, all he has to pay is $1,000, which I'm sure you told him, and he is not going to have, you know, to report once a month, call in twice a week, so it's up to him. The court is inclined to give him standard pretrial release, is what I'm saying, or he might want to reconsider the $1,000 bond.
Judge, and I guess Mr. Giles is now requesting, I guess, a $100 bond on count one.
Well, that's what he pays if he has a $1,000 bond. That's what I'm saying.
Plus collateral.
My understanding is, Judge, and that someone would have to come up with some sort of collateral.
Plus, the bondsman's involved in case if he does fail to appear.
All right, this is what the court's going to do. Does he want to resolve his case today with the driving while license is suspended?
That's what he's asking me to do.
All right, sir, raise your right hand. Do you swear and/or affirm to tell the truth?
I do.
All right, put your hand down. Is your name Daryl Giles, Giles?
Yes, ma'am.
All right, Mr. Giles, you understand that if you get 3 convictions within 5 years of driving while license is suspended, your license is going to be suspended for a habitual traffic offender. Do you understand that?
Yes, ma'am.
All right, you also understand that I don't have your driving record, so I don't even know where you're at in the scheme of things, so you could admit to this charge today, and your license could be suspended for 5 years. Do you understand that?
Yes, ma'am.
You also have a pending felony case, and by you admitting and pleading guilty or no contest to this driving while license is suspended charge, sir, it could affect your sentencing in your possession of cocaine case. Do you understand that?
Yes, ma'am.
All right. So you want to waive your right to a trial, sir? You want to give up your right to a trial, or you want to admit to the trial? Anybody forcing you to do this?
No, ma'am.
Are you under the influence of any alcohol or drugs?
No, ma'am.
All right. Have you ever been treated for a mental illness?
No, ma'am.
All right. Are you on any medications?
No, ma'am.
You understand that if you're not a U.S. citizen, a plea of his charge could result in deportation proceedings?
Yes, ma'am.
All right, understanding what I just explained to you. You want to plead guilty, not guilty, or no contest to driving while license is suspended?
No contest.
Court's going to accept your plea, find that's freely and voluntarily entered. Court has reviewed the court file and finds probable cause for the plea. The court's going to adjudicate your time, serve you, impose court costs of $293. The court will give him 90 days to pay. If he needs additional time, he can make a request through his division judge. As far as the possession of cocaine, the court will do a $100 bond. Sir, your address is 624 Northwest 20th Street, Pompano Beach.
Yes, ma'am.
All right, sir, look for your court date. Good luck to you.
Good luck, sir.
You have 30 days to appeal the sentence of the court. If you can't afford an attorney, one will be appointed. All right, so, Ms. Sheila, did you look at this order for Ramsey Hussan and it's acceptable?
You're a man, before you pass that, I'm gonna scan it in.
Sure. Okay.
Thank you.
You're welcome. You're welcome. He was not time served. No, it's okay.
And you got cash sticking in your pocket. And I'm really glad you didn't just completely run that thing over and just smash it in the pieces.
I didn't have a I found the bag empty, probably swung out.
I have no idea where it came from. Just let me know.
Okay, so next one's gonna be, last one on this detox is Justin Berry, please.
Mr. Berry is approaching, Judge. He has
Page-
private counsel.
Page 27 of the docket. Thank you. Hello.
Hi, Judge. Good morning, Scott.
Okay. Sir, your attorney's here. Can you see him and hear him?
Yes, ma'am.
All right, sir. All right, sir, you have a charge of burglary, unoccupied dwelling, unarmed. Need to talk about bond. Count 2 is criminal mischief between $200 and $1,000. First offense. Count 3 is resisting an officer and obstructing without violence, same as count 2. No bond attached to that, which is essentially an ROR on counts 2 and 3. Court does find probable cause unless I hear an objection.
I have an objection.
Sure. Sir, can you do me a favor so I can hear your attorney better? And hit that button in front of you. Thank you. I'm sorry, sir.
I think at best this is a trespass with a criminal mischief. There's no.
You might want to talk. Sir, can you hear your attorney? Nod your head yes or no.
Justin,
All right.
don't speak, okay? Just don't speak.
Okay.
I think at best, in the light most favorable to the state at this stage in the case, based on the facts as asserted in the probable cause affidavit, this does not rise to the level of a burglary. It's a criminal mischief and possibly a trespass and the resisting without violence that follows. But there's entry to the curtilage, yes, but there's no intent to commit a crime there.
Okay, state.
Your Honor, the crime that he intended to commit was the criminal mischief when he threw the flashlight into the man's home. Your Honor, even though he wasn't charged with it, there is PC for shooting at or throwing a deadly missile into a dwelling as well, Your Honor.
Okay, but I believe you're only talking about count 1, the burglary, unoccupied dwelling, unarmed?
Correct.
Okay.
Your intent was to commit a criminal mischief, Your Honor.
If you're going to find that that's not one continuous act and you're going to find probable cause, then I would assess that the bond be something reasonable, somewhere in the $2,500 with the standard pretrial.
Okay.
Well, is the court finding probable cause because bonds is separate?
Court does find probable cause.
Your Honor, I'm going to be requesting a $15,000 bond. While it says burglary unoccupied dwelling, it was an occupied dwelling. This man was home when this burglary was committed. Mr. Berry followed him home. Whatever his reason was, he claims that he was run off the road. He could have called 911. He chose to follow this man home, throw a flashlight through his window. He has 4 prior failures to appear. Your Honor, just so the court's aware, he was arrested January 2nd on court orders.
His bond was revoked on 3 possession charges, and those cases were resolved to a short jail sentence.
Judge, I didn't interrupt counsel when he was making any requests or arguments.
Right. I'll give you time to respond. Don't worry. Go ahead.
Your Honor, he received this jail sentence. He was just released May 24th of this year, 5 days before this incident.
Mm-hmm.
(2017), and that was for possession of alprazolam, a grand theft in 2017, possession of cocaine 2017, 07 sale delivery of cocaine out of near convenience store or business, and it's got priors out of Collier County. Requesting $15,000 bond, no victim contact, no return.
The lifelong resident of Broward County has no violent prior criminal history. I would ask for something more reasonable than $15,000, which is going to be tantamount to no bond.
All right, let me ask you a question. Is your client's address 4351 Southwest 52nd Court, Dania Beach?
Yes, Your Honor.
How long has he lived there?
I think
Approximately.
this is a residence that his mother moved into when he was in custody, but he's lived elsewhere in Broward County for the past 30 years.
Okay.
Is that correct, Justin? This is a new address? He's not responding, but I believe that to be the case, that his mother just moved into this residence while he was in custody, and that's the address he returned to when he was
I don't know if he can hear you.
It's fine.
He said he can't hear you, so you might want to repeat yourself.
The Dania Beach address is a new address, correct? Your mother moved there when you were in custody?
I've been at that address for 5 years. I've been living in Broward County for 25 years.
Okay.
Send him an email, please. CC it to me.
Apparently that address is, they've been there for 5 years. I misunderstood from speaking to them.
Okay. All right, sir, this is what the court's going to do. No victim contact, direct or indirect, with the alleged victim in the case with the initials SRH. No victim contact. Did you hear me explain what that means before, sir? No contact in person, no social media, nothing through third parties. Obviously, it doesn't include you. All right, no return to 4780 Southwest 65th Ave, Davie, Florida. Standard pretrial release, $3,500 bond on count 1. Thank you, sir. Any other private attorneys? Step up. Who do we have, Michelle, for private attorneys? Okay, Dana Michael Aiello. Is that the case you're here on?
Yes, Judge.
Okay. Do you have 1 or 2 cases?
Sorry?
1 or 2? Who has Polk? Someone else have Polk? Okay, we'll call you after this one. All right, so Dana Michael Aiello. Is that your name, sir? Page 17 of a docket.
Yes, ma'am.
All right, good morning, sir. How are you?
Been better.
All right, I can imagine. All right, sir, you have count 1, burglary of an occupied dwelling, unarmed. No bond attached to that right now. We have to see what the state's asking for and what your attorney's response is. And we have grand theft between $300 and $5,000 bond. Court does find probable cause unless I hear an objection. State, what are you requesting for count 1? And sir, and if you can't hear your attorney when he talks or anybody else, please let us know, okay?
Yes, ma'am.
Thank you.
Your Honor, I'm going to be requesting a $20,000 bond on count 1. This is a burglary of entering into an occupied dwelling. His criminal history, 2012, trafficking oxycodone between 14 to 28 grams, trafficking morphine between 4 and 14 grams, sentenced to 22 months in state prison as a habitual offender. Trespass 2011, leaving the scene of an accident 2010, violation of a domestic violence injunction 2011, possession of methadone 2008, leaving the scene of an accident with an injury, DWLS causing serious bodily injury or death, DUI serious bodily injury 2001, battery 99, burglary of a structure 95, battery 94, grand theft 94, battery 94. End of record.
Okay.
Good morning, Judge. Although I don't have any objection with regards to probable cause, there obviously is enough in here for probable cause, but what we're not seeing is the full story. Obviously, when the officers write up the report, they only write, what's in there to sufficiently get through the magistrate hearing. And it's a little confusing. I mean, if you look at this, it kind of leads you, if you just look at the probable cause affidavit, it kind of leaves you with the impression that the defendant broke into the house. It doesn't actually say how he got into the house, and that's what I want to focus on. It leaves you with the impression that the defendant broke into the house, and then while surreptitiously rummaging through the victim's property, he comes out of his bedroom and notices the defendant. He takes his cell phone and runs out. That's not how it went down. Obviously, the police aren't going to put in all of the facts that are favorable to the defendant. Specifically, that although it's going to come out later on down the line in a motion to dismiss with regards to count 1, the burglary, I don't have the objection to probable cause based on what's in the report. However, what's not listed here is that the victim has a roommate. All of the individuals know each other. Mr. Aiello, the victim, and the victim's roommate, they all know each other. They all work together. In fact, the victim and Mr. Aiello were, up until about a few days before this incident, business partners. So Mr. Aiello had a disagreement over some finances with his business partner, the victim. He goes to his apartment, a place that he's been many, many times in the past, knocks on the front door. The roommate lets him into the apartment. At the time, the victim is in his bedroom. The roommate had let him into the apartment, so he was there on invite. And again, not listed in the report, but again, that's not what we're here for today. I just want the court to be fully aware of what's going on here. They had a disagreement over finances based on their joint business ventures. Without getting too much into detail, they work in contracting type businesses, working on houses, and the partner kind of just upped and left Mr. Aiello holding basically a bag full of issues with all the clients. When is this work going to get done? So he went to confront the victim at his residence. He was let in. I have no argument with regards to the grand theft. Mr. Aiello was wrong, took the guy's cell phone in the course of an argument, and then he left. It was over finances regarding their joint business venture. He was allowed into the house, although I do understand why the court has defined probable cause based on what's in the affidavit. But based on those issues, the fact that, admittedly, Mr. Aiello has a little bit of a criminal history. I've known Mr. Aiello for a while now, almost 5 years. I originally met Mr. Aiello throughout the course of representing him on those trafficking charges. And I briefly want to explain that Mr. Aiello previously had a drug problem. He was in one of those recovery first step houses. And the police had another individual who, like a CI type situation, who they had approached Mr. Aiello at the sober house. That was the basis for a motion to dismiss, to which we wound up negotiating with Mr. Ted Dowse in the drug trafficking unit.
Okay.
So it's a little issue of police misconduct there, targeting someone in the sober house. But with regards to this charge, I've known Mr. Aiello for 5 years now. He's been doing great ever since we got him out of those issues a few years back. He has turned everything around with regards to his family and professional life. So with regards to the $1,000 bond on count 2, no objection. But I would ask for a $1,000 bond as well on count 1. Understanding the court has to find probable cause, but based on the additional information, I think that charge is going to go away very quickly.
Okay. Does he live at 2500 Calamondin, Calamondin Circle, Coral Creek?
Is that your address, Dana?
No, that's my dad's address. I'm at 6154 Southwest 1st Street, Margate, Florida, 33068.
All right, so is that where he wants to get his mail, at the Coral Creek, or does he want the other address?
Which one, Dana? Where do you want the mail?
Send it to my house, please.
All right, can you say that address a little slower, because I'm writing it down, sir?
I'll tell you what. Send it to my father's. That would be great. 2500 Calamondin Circle.
Okay.
That way.
All right, you can call your attorney up. Okay. All right, so this is what the court's going to do. No victim contact, direct or indirect, with the alleged victim with the initials TMM. You are not to return, sir, to the 1681 Northeast 1st Avenue, Pompano Beach, Florida. Do you understand?
Yes, ma'am.
All right, if you go back there, you will be arrested. Don't even go on the block, sir. Okay? Court is going to set bond on count 1 at $2,500 and on count 2 at $1,000. Thank you, sir. Good luck to you.
Thank you very much, Your Honor.
You're welcome. Have a good day. Sorry for the wait, but we have to call the other people.
Your Honor.
Hold on, sir. Don't talk about the facts of the case.
I'm not. I was going to request that Mr. Greenwald call my dad to post my bond.
Right away.
All right, so it's a total of $3,500. He does 1681. All right, thank you.
Thank you, Judge. I came later today.
Good.
I didn't show up right at 8:30.
All right.
Have a good day.
You too. Thank you. All right. you CC me? No? CC me too. Okay, here you go, Ms. Patrice. All right, we have another attorney, page 20. Jaylene Polk. Hello.
Hey, Judge, how are you?
Good, how are you?
Good, thank you. Judge, I'm receiving some text messages that his family was attempting to postpone this morning. I don't know if it went through.
All right. All right, let me just ask, are you Mr. Jaylene Polk, sir?
Yes.
All right, it's page 20 of the docket. We have a private attorney. Can you just announce your appearance? Thank you. All right, do you know confinement if bond's been posted? It's $1,000 bond total. No? Did you say no, or are you still looking? I'm sorry. Okay, I couldn't hear. Okay, so let me just tell them what the charges are, and we can just go from there. All right, sir, you have possession with intent to sell, manufacture or deliver cannabis, $1,000 bond. 2, 3, and 4 are actually no bond attached to them, which is basically an ROR. Count 2 is drug paraphernalia, possess or use, no bond attached, ROR. Count 3, resisting an officer or obstructing without violence, same thing as 2. And actually count 4, failure to wear a safety belt, is not for magistrate. So you're asking to leave $1,000 bond in place, sir?
Yes, Judge.
Okay. All right, sir, your bond should be...
Your Honor, just to advise the court, Mr. Polk is out on bond for possession of cannabis with intent to sell.
Okay. All right, court's going to take no action on that.
Thank you, Judge.
So, $1,000 bond. Thank you. Morning. Who do we have, Mr. McLaurin's page number and name?
Judge, on page 10 of the docket at North Broward, we have Robert McGowan.
All right, so I'll tell you what. Mr. Romero.
Yes, Judge.
Tell you what, let's take Robert Mitchell, and then I'll give you guys a break because I have Mr. McLaurin's for 2 cases, okay?
Okay, Robert Mitchell.
Robert Mitchell,
On page 17.
page 17. This will be a fast one. Okay, Mr. Mitchell, you have capious misdemeanor, $25 bond. That is for...
It's a sleeping on the beach, Judge.
For sleeping on the beach. You also have a parole violation, sir, which is a no bond hold. You are going before your division judge this coming, June 6th is this coming Wednesday at 9 a.m.
Mr. Mitchell, I had an opportunity to look at that case, and what actually happened was the judge back in November ROR'd you. They didn't resolve the case. So you have an opportunity today to resolve the case, and
Well, here's the thing, is this going to violate him on his parole?
Well, he's under the notion that this is what caused him. He actually went back into custody in November of 2017 to Department of Corrections. And at the time he went into custody in the Department of Corrections, this case was existing. So I don't believe this will violate his parole, Judge. This isn't this is not the source of his parole violation. So he wants
All right,
to
as long as you're sure of that and he understands that.
That's not the reason my parole was violated this time.
Okay. Mr. Reedy, if you want, you can take a break.
Sure. I'll be right back.
All right, take your time because we have 2 cases.
He wants to resolve this.
All right, so Mr. Mitchell, you want to resolve your sleeping on the beach charge?
Yes, I do.
All right, raise your right hand, sir. Do you swear and or affirm to tell the truth?
I do.
All right, is your name Robert Mitchell?
Yes, it is.
Mitchell?
Yes, it is.
My understanding you wish to waive your right to a trial? You should write down the
Yes.
times. I need my pad. I don't know why we're getting the next one. Okay. All right. Is anyone forcing you to do this?
Nope.
Are you under the influence of any drugs or alcohol, sir?
No.
Have you ever been treated for a mental illness?
No.
You understand that if you're not a U.S. citizen, a plea of his
Yes.
charge. Let me finish the question, sir, because I just have to get it on the record, okay? It's just part of the process, so just bear with me. Sir, look at me. You have to look at me, not the person there, okay? Because I just want to make sure you're doing this freely and voluntarily. You understand that if you're not a U.S. citizen, a plea of his charge could result in deportation proceedings that affect your ability to remain in the United States?
Yes.
Okay, understanding what I just explained to you,
Yes.
are you pleading guilty, not guilty, or
Yes.
no?
No contest.
All right, I have to say what the charge is, sir. Do you want to plead guilty, not guilty, no contest, sleeping on the beach, sir?
No contest.
Court's going to accept your plea, find that's freely and voluntarily given. Court has reviewed the court file and finds probable cause for the plea. Court is going to adjudicate you and time serve you.
Okay.
Court is going to adjudicate you, time serve you, sir, $78 in court costs. You have 30 days to appeal the sentence of the court. If you can't afford an attorney, one will be appointed. Is there someone talking to you, sir?
They said they just tell me to let you finish the question.
Okay. It's adjudication, time served, $78 in court costs. You have 30 days to appeal the sentence of the court. If you can't afford an attorney, one will be appointed. You are going to be held no bond on the violation of probation. Thank you, sir, and good luck to you. Next one is Robert, is it McGowan?
Yes, Judge, he's over in North Broward.
All right. For Mitchell?
It's on page 10, Robert McGowan.
Okay, hold on, I have to give the clerk something. Okay, Robert McGowan. Sir, you have a capias, good morning, sir, a capias misdemeanor. This is from 2011. This is an alcoholic beverage violation, Mr. McLawrence.
Yes, Judge. He also has, it reads as a Dade County hold, but he informed me that it should properly read as a Department of Corrections hold.
I don't have, all I have honestly on my sheet is the capias misdemeanor $100 bond going before Division MH this coming Tuesday. Do you know if there's any hold on him, confinement?
It was corrected. It was booked with a Dade County hold. He came in from Calhoun CI. And
Okay.
his release date is June 1st from Department of Corrections.
So Judge, what I was going to ask is if you could ROR him on our municipal ordinance, so I could file a motion to dismiss based on statute of limitations, and he could then, I guess, process out on the DOC matter.
All right, here's the thing. He does have a court date, June 5th at 9 a.m. So if he's going to be released June 1, if the judge is going to make him show up, or if you can waive his appearance, because since you're his attorney, I don't know about that. It is Judge Cal Evans.
Judge, I'd file the appropriate paperwork.
Okay, so you have to advise your client whether or not he should show up June 5th so he doesn't get a warrant out for this 2011 case, okay?
Right. I gave my number to the deputy, and I believe the deputy gave him my phone number so he could contact me whenever he's released.
All right, well, here's the other thing. Your client has no mailing address. So I don't want him to get arrested again. Do you have an address, sir? We can send you notice?
I gave it to the jail last night.
What is it, sir?
It's 2107 North Dixie Highway,
Hold
West
on.
Palm Beach.
Hold on. Any apartment or any unit
No,
number?
ma'am. No, ma'am.
What's the zip code, sir, if you know it?
33407.
All right, so I have it down as 2107 North Dixie Highway, West Palm Beach.
Yes, ma'am.
All right, I'm updating your address.
Can we address the hold?
I can't do anything with that, sir, today. That's up to Dade County or the Department of Corrections, okay?
Okay.
All right, good luck to you, sir. Thank you.
Thank you.
All right, we're going to go off for one moment. Okay, Mr. McLawrence.
Yes, Your Honor. Judge Stephen Fernandez is at North Broward.
Okay,
He's on
North
page-
Broward, do we have Mr. Stephen Fernandez, please?
He's on page 12 of the docket. He's a medical reset judge.
Okay. Okay, this is the third day, I believe.
Yes, Judge. Judge, I was going to, I was going to request that the court would set Mr. Fernandez possibly in Judge Wren's division. I see that he has had previous cases before Judge Wren, so I'm not sure if the cause of his medical reset is psychologically related or not, Judge.
Okay, we'll transfer per your request. Okay, so can we waive his appearance?
Today's hearing? Yes, Judge.
Agree to probable cause?
Yes, Your Honor.
Okay, we'll leave the bond and we'll transfer it to Judge Wren. What about Robert McGowan? Did we do him?
Yes, Judge. He's the gentleman who has the DOC hold.
Okay, any other cases for you?
That's all.
Okay.
Thank you, Judge.
Thank you. All right, let's begin our regular docket. Pam, regular docket begins.
May I have a motorcycle badge? Okay.
Absolutely. You're welcome. Yes? Okay, all right. Let's start with the domestic violence docket. Michaela Wellington. There you go, on the transfer order. Michaela Wellington, please. Thank you for your patience. We just have to call the people out of order that the jail requests, and then we have the private attorneys and Mr. McLawrence. Okay, I'm sorry you had to sit here and wait. All right, are you Mr. Wellington? Or Miss Wellington?
Yes, she is, Judge.
All right, you are charged with one count, touch or strike battery, domestic violence. Court does find probable cause. Anybody wish to be heard?
State be requesting a $1,500 bond, no victim contact.
Okay, there's going to be no victim contact, direct or indirect, with the alleged victim with the initials ACJ. Did you hear me before say, ma'am, what no victim contact, direct or indirect means?
Yes, ma'am.
Okay, because I can repeat it if you need me to, ma'am. Okay? All right, so there's no victim contact. They're asking for a $1,500 bond. What's your response, Mr. Romero?
Judge, my understanding is this is Miss Wellington's first criminal arrest ever.
Mhm.
She's currently working. She works at a hotel called Cirque Hotel, which is located in Hollywood. She just obtained that employment about 3 months ago, making about $12.50 an hour. She's going to contact one of her friends to reside separate and apart from the alleged victim. So she's going to, her friend, I believe, resides in Boynton Beach. From what she informed me, there's really nobody that she can call to help post her monetary bond. So considering, Judge, this is a misdemeanor offense, no prior record, we're going to be asking your court to release her on pretrial release, Judge.
And what also appears, though, the victim is not cooperative, Judge, as he refused to complete an affidavit and refused to allow photographs of himself to be taken.
All right, ma'am, is your address 7539 South Yates Boulevard, Chicago, Illinois? Is that your mailing address?
No, if I can change it.
Sure, let me know what it is, but keep in mind I'm writing it down.
It's 414 South Scott Street in Algonquin, Illinois.
Okay, 414 South Scott Street. Spell that town name.
ALQUON.
Not QU?
No, it's ALQUINGIN.
Okay, Illinois, IL.
Mm-hmm. 60102.
It's ALGONQUIN.
All right, give me the name ALG.
ONQUIN.
All right, state, want to be heard further?
She's got no ties to the community. Physical evidence would support the victim's allegations.
All right, court's going to ROR, standard pretrial release. Make a copy of that. Thank you, ma'am. Good luck to you.
Good luck, sir. And there's the map right there. You have to report to pretrial within 24 hours. You'll be released late tonight, so most likely tomorrow before 12 noon. Good luck.
All right, hold on, Mr. Romero. Miss Patrice is asking me a question. Yes?
Oh, come on, Miss Wellington, hold on.
If she wants to return to Chicago, yeah. Then she doesn't, if she shows, is she going to return to Chicago or live here?
No, she's going to be residing here, Judge.
Okay, what's her address here?
She's going to be residing with her friend in Boynton Beach. She doesn't have that address.
All right,
but
she's to provide it to pretrial services within 7 days of being released, okay?
That's fine, Judge.
Okay. All right, so ma'am, she'll do it in 7 days, okay? She'll tell pretrial services her address in Boynton Beach. Okay?
Thank you, Judge.
Yeah, yeah. And when I say 12 o'clock, they really have till 3. I'm just trying to get them there early. Okay. Joey Michael Bryan, please. I think that's it for the domestic violence today. Okay. Okay, are you Mr. Bryan, sir? Sir, you have an out-of-state hold. There's a no bond hold. I don't know what state it is. Pardon? Pardon? Okay, it's out of Minnesota, sir. It's for a check of forgery. You have a no bond hold. We'll see you in extradition court Tuesday or Thursday at 1 p.m. Good luck to you, sir. We'll see you then, okay? Sandra Charisma.
Bonded, Judge.
Beatrice Wise, please.
Medical loan, Judge.
Medical loan. Today's date. No. Patricia Garihi.
I believe North Broward.
All right. Okay, Patricia Garihi, please. North Broward.
North Broward, she's coming.
Hi.
Morning, Judge.
Huh?
Main jail's a little loud.
You know, even though I have this on here, it's kind of hard, you know, like when I hear everybody, it's kind of hard. But the biggest problem is, my concern is the inmates can't hear their attorneys. I don't know, maybe we can lift that up. I tried lifting it a little. Because it's sunk down. You can? Yeah. All right, so if there's a problem with it, then we can just have, we'll know this afternoon when more private attorneys or somebody comes in. All right, thank you so much. Sorry about that. There was an audio person here. We were having a little bit of an issue. All right,
No
so are
worries.
you Patricia Garihi?
Garihi, ma'am.
Garihi, I'm sorry. You have
no worries.
trespassing, unoccupied structure or conveyance,
Yes, ma'am.
$25 bond. Count 2 is a probation violation. You are going to be held no bond. You are going before your division judge, Judge Barbara McCarthy, this Monday, June 4th at 8:30 a.m. $1 bond on count 1.
That's fine, Judge.
All right, and no return to 1705 Northeast.
1701 Northeast, 29th Street. 27th Street.
Okay, no return to the used car dealership, okay, ma'am?
Yes, ma'am. It was raining very heavy. That's the only reason I said in the car.
All right, ma'am. So, $1 bond. Good luck on your probation violation.
Oh, I'll call your aunt, Patricia.
Pardon me?
So I'll call your aunt for you.
Megan Ann Morse, please. I believe we have a family member, page
Yes, Your Honor, her
7.
father is here.
Hello, sir. How are you? You can step up to the podium. Are you Megan Ann Morse, ma'am?
Yes.
All right, we have your father here today. Sir, if you could state your first and last name and spell your last name for the record.
William Morse, Morse.
Can you hear him, ma'am?
Yes.
Okay. All right, so, ma'am, you're charged with burglary, unoccupied conveyance, unarmed. We need to talk about bond. Count 2 is petty theft, second degree, first offense. It's basically an ROR. And count 3 is loitering or prowling. There's no bond attached to that. The court does find probable cause. State?
Um,
I'm going to ask for an ROR, Judge. I think probable cause can be found, but I think it's kind of weak. Something taken from one of the vehicles was found in the possession of her co-defendant, who we magistrated earlier, Mr. Dario, but nothing was found on her. Her statement to the police seems to indicate that she was just looking in cars. But that issue aside, if the court wants to find probable cause, I still believe that Ms. Morse is a good candidate to be released on her own recognizance. She's been a resident of Florida all of her life. She has family here. Obviously, her father is here this morning and has been waiting patiently for her case to be called. She will
Sorry
be living,
about that, sir.
She will be living with her parents. She works 2 jobs. She is also a high school graduate. She graduated from Northeast High School in 2011, and she is attending FIU? FAU. Okay.
What year is she in FAU?
Well, she started out in Broward Community, and now she actually took this semester off, and she's going back next semester. She's got a couple years in so far.
Okay, good.
She's a straight A. I don't know what's
Okay.
this.
Well, we don't want to talk about the facts of the case, but.
No.
All right.
She's not going anywhere, Judge. She's not a flight risk. It's not a violent crime, and she has no prior criminal history.
Okay, so you're asking for?
I'm asking you to release her on her own recognizance.
State?
I don't have an issue with the court not imposing a bond. I would ask for a pretrial. It is still a burglary. It may not be violent, Your Honor, and I'm sure as the court has noticed just on today's docket, car burglaries are becoming an issue in Broward County, and it is a bit of a concern, and I think some supervision would be appropriate.
Would you agree this is her first offense ever?
If I had priors, Your Honor, I would have advised the court.
Okay, I'm just asking.
Right? I'm just stating.
All right, no victim contact, direct or indirect, with the alleged victim with the initials TB. Count 1 is an ROR. Thank you. We're taking a break.
Madam Clerk, on the docket, do you have, is there something that prints them in alphabetical order by any chance? No? So it's just kind of explore the docket. I'm trying to find out if this person's going to be on the docket. The last name is Williams. Well, we completed the docket in your absence. It was real expedited.
Sounds good, Judge.
No, I didn't. I actually have a case I was called by a judge in Indian River County to come and try to resolve, because apparently there's been some issues.
Look at you, you are.
It may not be, but I'm taking care of it whether it is or isn't, because apparently it's been up 4 times, and the jail keeps saying the paperwork's not correct. It's Zachary Williams. Is he on the docket? That's did I say? I'm sorry, St. Lucie County. You're correct. So what? I want to know if he's still in custody. The judge and Judge Eisenhower contacted my office yesterday and again today on Zachary Williams. He's being held on a warrant. He has a bond of $2,500, and for some reason the jail's not letting him bond out, and Judge Eisenhower wants to know why. So, if he's not there, then it's moot.
Zachary Williams, you said, Judge?
Zachary Williams. So it's a St. Lucie County warrant for domestic violence.
Because on the teletype that was received.
I don't see a Zachary Williams that was arrested recently. I don't. No, I know who they're talking about because I talked to Sarah Noah about it yesterday.
Do you have because it's not a Broward County charge? Would you have his information?
Your Honor, the weird thing is I did a search in BSO Pics just under the last name Williams. If it's spelled, I don't see anyone by the name of Zachary Williams that was
Zachery. He spells it a little unconventionally.
So the first name is C-A-C-H?
No, Z as in zebra. A-C-H-E-R-Y. Well, he may have bonded out overnight or this morning.
But it would still show in BSO Pics if he was arrested. Okay, I've got it. That's okay because the.
Okay, sorry.
Okay.
So the guy came in on a St. Lucie County home. Per the hit confirmation from St. Lucie, he was to be held no bond.
Okay.
And then the attorney came pretty much 4 days straight saying that this is not incorrect. She was advised several different times that she would have to notify St. Lucie County because we communicate through teletype. They have to tell us that this warrant has either been vacated, squashed, and released their home because we don't serve jurisdiction on St. Lucie. And then she just persisted that she was going to make Broward take care of it. We reached back out to St. Lucie County again, pretty much forcing them to say, hey, are you holding them? Do you want them? You coming to get them? Come get them. We did all of that. Per St. Lucie County, he was still to be held on bond, and then we make a record.
Do you have the paperwork? Because they've sent me the warrant from St. Lucie County. It shows a $2,500 bond in 2014 3858A.
3858, yeah.
Okay. And I have the warrant right here, signed by Judge Nelson, and an email from Judge Eisenhower that he is not on a no bond hold. The date of this warrant is November 18th of 2014.
And because they have no way of,
so
that judge, which is in St. Lucie County, who signed the warrant, that should have went to their warrants department.
I'm just telling you, I'm going to do an order demanding you to release him. So what do you want me to do? I'm not going to wait for this nonsense to continue. This gentleman's been held for 4 days improperly. So what do you need from me? Do you need a specific order that tells you you must release him on $2,500? The bond is, I'm setting it at $25 per Judge Darrell Eisenhower of St. Lucie County and Judge Catherine Nelson of St. Lucie County. And I have a copy of the warrant in my hand that they've emailed me. So if I need to do just a blank order, that I'm ordering Broward Sheriff's Office to release this gentleman upon his posting that bond in that case. And then that should be able to there's more than one way to skin the proverbial cat. I think we could all agree if it was us sitting there for 4 days waiting for this stuff to be taken care of. I'm sorry? Oh, and that's just a saying. I wasn't trying to say we should skin a cat. Oh.
My son says, I'll help you detox.
I'm here to handle one case. And then I've got too much to do. I wish I could. No, I think we're done. I got an email from and a contact from Judge Eisenhower in St. Lucie County that this gentleman should be not being held with bond. He sent me a copy of the warrant. I've confirmed. So he's being held in Broward for at least 4 days, if not longer, when he should have been able to bond out. There's apparently some sort of glitch in the system that's saying it's a no bond, and that's inaccurate. What day next week am I supposed to be here next week? I'm going to be here a couple days coming up. But I don't know when. I mean, it's on my calendar. All right, so I've got a copy of I'm going to make a part of the record Judge Eisenhower's email, the arrest warrant. I hope this takes care of everything. And jail, if there's any question whatsoever, please contact me immediately. Please do not continue to hold this gentleman. I don't have a paperclip up here. No, she's got this gold stapler that weighs about 500 pounds here. All right, I think that's it, Madam Clerk. Thank you so much. You folks stay well. Thank you.
See you next week.
I'm not sure exactly. I know I'm coming up several times because Judge Malika is going on a nice vacation, she said. Let me turn that off. Nope, that's the wrong thing to turn off. There we go.
I have nothing to do with that one. That Judge Lee did. Okay. They're bringing down whatever. Okay, Charnel Nicole Johnson, please.
She's here, main judge.
All right, thank you. All right, Ms. Johnson, how are you, ma'am?
Okay.
All right, ma'am, you have robbery with no firearm or weapon. You need to talk about bond. You also have count 2, touch or strike battery, $1,000 bond. Counts 3, 4, 5, ma'am. I'm sorry, 3, 4, 5, or 6. There's no 5 here. I don't know what happened to 5. Is a probation violation, no bond holds, and you have says count 8, and this is wrong, this cover sheet. I don't know who did it. So this is what I'm gonna go off the booking report. Count 1 is robbery, no firearm or weapon. We need to talk about bond. Count 2 is touch or strike battery. Counts 3, 4, and 5 are probation violations. You are going before your division judge, who is Judge Michelle Tobin Singer, on June the 7th at 2 p.m. You also have the next count, which is the last one, which is 6. It says here 6 twice, is tampering in misdemeanor proceedings. We need to talk about bond. State?
Requesting a $7,500 bond on count 1, $1,000 bond on count 6, no victim contact.
And count 6 is, just for clarification, tampering in the misdemeanor.
Yes, ma'am.
Okay, and that's how much, 1,000 you said?
Yes.
All right, so 8,500 total for those two, and so it would be 9,500 with the 1,000. Court does find probable cause. Go ahead, Mr. Romero.
Judge, just speaking of Mrs. Johnson, 7,500 for 1,000 on 2, is 1,000 on 6, something she's not going to be able to afford. She's been here in Florida her whole life. She's 34 years old. At this time, she's not employed, so she has no income coming in. I do realize she has no bond holds, Judge, but I'd ask you to set a reasonable bond on count 1 considering her financial circumstances.
All right, tell me what she can afford.
We'd be asking you for $2,000 on count 1, Judge. Leaving count 2 at 1,000, 6 at 1,000.
Okay. So $4,000 total bond, you're saying?
Yes, Judge.
Okay, just wanted to make sure. All right, ma'am, you're to have no victim contact, direct or indirect, with the alleged victim with the initials QM. You are not to possess any firearms, ammunition, or weapons. All right, so this is what the court's going to do. On count 1, the court is going to do a $3,500 bond. On count 1, a $1,000 bond. And count 6, a $1,000 bond. The probation violations are no bond holds. Or excuse me, on 6, I'm going to do $999, which is the tampering and the misdemeanor proceedings. Thank you, ma'am. Good luck to you. Next one is Brianna Valls, V-A-L-L-S.
She bonded, Judge.
Okay. Lamont Tyro Green, please.
Mr. Green is approaching, Judge. He's here on me.
All right, good morning, Mr. Green. You have trespassing on occupied structure or conveyance. This was with regard to the 7-Eleven. I believe it's at 460 West Broward Boulevard. Court does find probable cause. Court's going to order no return to the 7-Eleven at 460 West Broward Boulevard. Do you understand, sir?
Yes. Yes,
Bond
ma'am.
set. Okay. Bond is set at $25. Anybody wish to be heard? Want to
Yes,
resolve the
Judge.
case
Speaking
today?
to Mr. Green, yes, he wishes to ask the court if you will consider resolving this case.
All right, State, what's your plea offer?
Offer be 10 days, time served, Your Honor. He was just arrested a little over 3 weeks ago for trespassing at the same location. Just on state priors, he's got 2, 3, 4. One moment, I'm just. How many arrests? 1, 2, 3, 4, 5, 6, 7.
Okay, Mr. Romero, just so you know, he was trespassed in 2017, 1, 2, 3, 4 times. Last time was October.
10 arrests just in the last couple of years.
Pardon?
And it was at the same location those 4 times?
Yes. So this is the 5th.
10 arrests in the last couple of years.
For trespass or similar?
All similar type stuff.
All right, so.
He wishes under circumstances, Judge, accept the state's offer.
All right, sir, raise your right hand. Do you swear and/or affirm to tell the truth?
Yes.
All right, put your hand down. Your name, Lamont Green, Green?
Yes.
Middle name, Tyro?
Yes.
All right. Okay, it's my understanding, sir, you wish to waive your right to a trial?
No.
Want
You
to
want to
give
give up your right to a trial?
Oh, yeah.
Anybody forcing you to do this?
Anyone forcing you to do this?
No.
Can you hear me?
Yes, I can.
Okay. Are you under the influence of any drugs or alcohol?
No.
Ever been treated for a mental illness?
No.
You on any medications?
Nope.
All right, you understand that if you're not a U.S. citizen, a plea to this charge could result in deportation proceedings? Yes?
Yes, I understand.
All right, understanding what I just explained to you, are you pleading guilty, not guilty, or no contest to trespassing, unoccupied structure, or conveyance?
I'm pleading no contest.
All right, the court is going to accept your plea, find that's freely and voluntarily entered. Court has reviewed the court file and finds probable cause for the plea. Adjudication per plea agreement. 10 days, Broward County Jail with credit for time served, $293 in court costs. Sir, if you go back to that 7-Eleven, you're going to get arrested, and you're probably going to get more jail time. Do you understand? So don't return there. 460
Yes.
West Broward Boulevard. Thank you, sir. Good luck to you, okay?
Good luck, sir.
All right, Craig Brown, please.
Mr. Brown is approaching, Judge. These are municipal ordinance cases.
All right. Hello, Mr. Brown. How are you?
How you doing?
Good, sir. You have 2 capious misdemeanors, urinating in public and carrying an open container. You want to resolve your case today for an adjudication, or would you like to fight these cases and I can appoint the public defender, the special public defender to represent you?
I want to resolve them today, please.
All right, raise your right hand, Mr. Brown. Do you swear and/or affirm to tell the truth?
Yes, ma'am.
All right, put your hand down. Is your name Craig Brown, B-R-O-W-N?
Yes, ma'am.
All right, you understand that. If you can't afford an attorney, sir, I would appoint an attorney, but you're telling me that you want to give up your right to that and give up your right to an attorney and resolve your case today. Is that correct?
Yes, ma'am.
All right, giving up your right also to a trial in exchange for resolving your case today and to be sentenced?
Yes, ma'am.
Anybody forcing you to do this?
No, ma'am.
Are you under the influence of any alcohol or drugs?
No, ma'am.
Ever been treated for a mental illness?
No, ma'am.
All right, how do you want to plead to urinating in public and open container?
No contest.
Court's going to accept your plea, find that's freely and voluntarily entered on each count, adjudication and time served on each count. $78 in court costs. It's just one case, Ms. Jackson? Thank you. All right, just $78 in court costs. The court will give them 90 days to pay that. You have 30 days to appeal the sentence to the court. If you can't afford an attorney, one will be appointed. Do you have a place to live, sir?
Yes, ma'am.
All right, thank you very much. Good luck to you. Have a good day.
All right, you too, ma'am.
All right, Jamie Naranjo? I'll let you say that, Mr. Romero.
Naranjo?
Okay. All right. Okay, sir, you have a capious misdemeanor for petty theft. No show at calendar call. Would you like to resolve this case today, sir?
He would, Judge.
State, is there a plea offer in this case?
Offer would be time served.
Adjudication, time served.
He wishes to accept the state's offer, Judge.
All right, sir, raise your right hand. Do you swear and/or affirm to tell the truth?
Yes, ma'am.
All right, is your name Jamie Naranjo, Naranjo?
Yes, ma'am.
How do you say it?
And Naranjo.
Naranjo, okay, sorry about that. Okay, you can put your hand down, sir. It's my understanding you wish to waive your right to a trial?
Yes, ma'am.
Anybody forcing you to do this?
No, ma'am.
You under the influence of any alcohol or drugs?
No, ma'am.
Ever been treated for a mental illness?
No, ma'am.
All right, did you speak to your attorney, Mr. Romero? You want to
Yes, ma'am.
inquire with regard to a theft, the third one being a felony?
Oh, first let me explain it to him, Judge. 1 second.
Did you find your friend? Good. Okay, we're gonna go off just. Romero, sorry about that.
No problem. Mr. Naranjo, I advise you some of the consequences of resolving a petty theft case today. Is that correct? Yes, ma'am. And I did advise you upon your third conviction for a petty theft, state could go ahead and enhance it and file it as a felony offense. You are aware of that? Yes, sir. Even if you're allegedly stole a misdemeanor amount, which would be like a $10 item, state has an option of filing it as a felony. Do you understand? Yes, sir. And knowing that you still wish to resolve it for time served today? Yes, sir. And give up your right to a trial? Yes, sir. Okay. Judge, you may inquire.
Okay, how do you wish to plead to petty theft? Guilty, not guilty, no contest. Court's gonna accept your plea, find that's freely and voluntarily entered. Court has reviewed the court file, finds probable cause, adjudication, time served, $293 in court costs. You have 30 days to appeal the sentence of the court. Can't afford an attorney, one will be appointed. Good luck, sir, okay?
Yes, ma'am.
Thank you. Herlin Guerrero?
Mr. Guerrero is here present, Judge.
State, do we have a plea offer on this?
On a Guerrier? No, Your Honor, not based on these allegations.
All right.
Judge, my understanding, Mr. Guerrier has been here his whole life. He can't afford to post a monetary bond at this time. He is working. He's looking for work. He lives in Hollywood. So considering this is a misdemeanor offense, nonviolent, Judge, we'd ask you to consider releasing Mr. Guerrier ROR.
Your Honor, it can be classified nonviolent, but there is a concerning element to it that, especially based on the information the law enforcement received, that he's throwing, what is he throwing? Throwing some type of object, shattering this woman's windows. And considering that he lives 3 apartments away from her.
Okay, Mr. Guerrero, you have criminal mischief, $200 or less. First offense, $25 bond. Court does find probable cause. So, state's asking for a $25 bond. You're asking for an ROR?
No, Your Honor?
Right, Judge.
I'm sorry. I'm actually asking for a $250 bond. I would know Mr. Guerrier. He's, as far as Broward goes, 2012 battery, 2013 burglary of a dwelling and theft. He was sentenced to 2 years state prison. Another battery in 2009. I have mental health concerns, especially considering the court is going to, I imagine, ordering no contact order if you haven't already. And just noting the proximity of the 2 parties.
Judge, $250 bond is going to be even more out of reach for Mr. Guerrier. So we're asking Judge for ROR.
All right. I don't know what apartment number he's in, but the alleged victim is at the same address in apartment 8. Seems it looks like now when I'm looking at the complaint affidavit, it says apartment 5.
That is what it says.
Is he in apartment 5?
Judge, I believe, and speaking of Mr. Guerrier, I believe it's about 50 feet apart from each other. but also he's actually looking to, he's looking for another residence. I guess he's not going to, once he finds a new residence in Hollywood, he's not going to live at that same apartment. So he's going to take a proactive approach. But Judge, right now, we're at ROR.
All right, the court's going to order no victim contact. Direct or indirect. However, I am going to allow him to remain. He may reside in apartment 5, but here's the thing. Sir, I don't know how far apart these apartment doors are from 5 to 8, but you can't have any contact. You see her approaching her door or leaving her door? Just walk the other way. You're saying he can't afford the bond, any bond at all?
No, that's why on that $25 bond we were asking for an ROR.
Standard pretrial release, ROR. But what does he do for a living?
Right now he's looking for work.
All right, standard pretrial release. And once he moves, I want a separate order. Once he leaves the residence, once he leaves and relocates, he's not allowed back to 6031 Polk Street. Do you understand, sir?
Yeah.
All right.
So, with the end of this month for my rent, I already paid my rent this month.
Judge, his plan is to move at the end of this month.
The end of May or the end of June? Because today's the 31st.
The end of June.
The end of June.
All right, so once the defendant relocates his residence, he's not allowed back to 6301 Polk Street. Do you understand, sir?
I got you.
Okay, sir, if you violate any of these terms, you'll probably have a higher, much higher bond or a no bond hold. Do you understand?
Yes, ma'am.
All right, thank you. Good luck to you. Tyson Edwards, please.
Mr. Edwards, come on.
Okay, Mr. Edwards, good morning, sir. You have trespass, failure to leave property upon order by owner. There's no bond attached to that. You do have count 2, resisting an officer or obstructing without violence. $100 bond. The court does find probable cause. Anybody wish to be heard?
Judge, Mr. Edwards is wanting to ask the court if you would consider resolving his case today.
He had a previous trespass warning on April 25th and then goes back there 35 days later.
Judge, he's advising me he doesn't plan on returning there. Also, one other thing, Judge, he advised me on June 6th, he's graduated from ATC. So he's trying to better his life, so he's trying to put this behind him. So, Judge, we'd be asking you to consider time served.
What's ATC, an air traffic controller? I hope not.
Atlantic Technical College.
Okay. Sorry about that.
What are you studying? GED. Oh, you're getting your GED? Congratulations, sir.
Okay, that's good, sir. All right, State, what's your offer on this?
Yeah, time served on both counts.
Adjudication, time served, but sir, you can't go back there again. You go back there and I see you there again, it's probably not going to be time served. Do you understand?
Yes, Judge.
Okay. All right, so raise your right hand. Do you swear and/or affirm to tell the truth?
Yes, ma'am.
All right. Is your name Ty Von Edwards, EDWARDS?
Yes, ma'am.
All right, you can put your hand down, sir. It's my understanding you wish to resolve your cases today?
Yes, ma'am.
Anybody forcing you to do this?
No, ma'am.
You under the influence of any drugs or alcohol?
No, ma'am.
All right, so you don't want a trial. You're giving up that right, and you want to plead guilty or no contest to trespass. Let me finish.
My bad.
It's okay.
I'm sorry.
I have to say the charges so we know what you're pleading no contest to, okay? All right, so how do you plead to trespass, failure to leave property upon order by owner, and resisting an officer and obstructing without violence? Guilty, not guilty, or no contest?
No contest.
Okay, you understand that if you're not a U.S. citizen, a plea to this charge could result in deportation proceedings?
Yes, ma'am.
You understand, sir, that you can't return to 2667 West Atlantic Boulevard, Pompano Beach.
Yes, ma'am.
And if you return there, sir, you're going to be arrested. You understand that?
Yes, ma'am.
All right. Court's going to accept your plea, find that it's freely and voluntarily entered. Court has reviewed the court file and finds probable cause for his no contest plea. Court is going to adjudicate him and time serve him on each count, $293 in court costs on count 1. You have 30 days to appeal the sentence of the court. If you can't afford an attorney, one will be appointed. No return, sir. 2667 West Atlantic Boulevard, Pompano Beach, Florida. Thank you.
All right, sir.
Good luck to you, sir, okay? Kevin Lavetta Jackson.
North Broward.
Medical reset, Your Honor.
Okay. Wold Lubin, please.
Who's the reset?
Wold, W-O-O-L-D, Lubin. Is that how you say your name?
North Broward. Yes, sir.
Hi, sir. How are you?
Good.
All right, sir. You have some ad charges: burglary, unoccupied dwelling, unarmed. We need to talk about bond. And count 6 is grand theft between $300 and $5,000. Court does find probable cause. Court is going to order no return to 1021 Southwest 22nd Ave, Fort Lauderdale, Florida. Do you understand?
Yes, Your Honor.
All right, and you're to have no contact, direct or indirect, with the alleged victim in this case with the initials A.A.J. Do you understand that as well, sir?
Yes, Your Honor.
All right. State, what are you requesting for bond on count 4?
Requesting a $10,000 bond, Your Honor. He's got 2 other pending felonies, a grand theft auto and a uttering a forged instrument, where he's being held no bond on that case for violating his pretrial release.
Hold on.
I was not on pretrial.
Okay. So Mr. Reedy is representing you. If you'd like a moment more to talk to him, Mr. Reedy, I don't mind.
I spoke with Mr. Lubin earlier today, Judge, and he understands he's being held without bond. I'd ask for a $1,000 bond on count 4. He's going to have to go in front of his division judge to resolve his no bond violations of pretrial release in any event.
Okay, so this is what the court will do. $24.99 on count 1, count 4, the burglary, unoccupied dwelling, unarmed, and on count 5, court will do bond at $999. No victim contact, sir, direct or indirect, with the alleged victim. What that means is no contact in person, calling, texting, writing, or anything like that. And the court also is going to do a GPS level 2. Thank you, sir. Good luck to you. And I'm only doing that on count 4, the GPS on the burglary. Jason Cuddy, please.
Judge, just for the record, Jason Cuddy, count 1 is not the magistrate.
Your main judge?
All right, Mr. Cuddy, is that your name, sir?
Yes, ma'am.
All right, sir, you have 2 counts. One's a capious felony, no bond hold, and count 2 is a capious misdemeanor. There's a $100 bond. The possession of cocaine is actually not for magistrate. It's a no bond hold. He eloped from Bark, and this was in front of Judge Michelle Tobin Singer. He has a court date June 7th, which is this Thursday at 9 a.m. Court finds probable cause. Anybody wish to be heard on the capious misdemeanor?
Judge's a municipal ordinance. So.
It says loitering where a sign is posted. Yes, it is. Okay, so $1 bond on that. Thank you, sir. Good luck to you. You'll see your judge June 7th. Matthew Thomas, please. And then after him is Arthur Kennedy Gates. Hello, Mr. Thomas. How are you?
I'm okay. How you doing?
Fine, thank you. All right, sir, you have 2 capious felonies. You need to talk about bond, I believe, and count 3 is possession of cannabis over 20 grams. We need to talk about bond. You do have a hearing coming up this Monday in front of Judge Scheer, Elizabeth Scheer, that is, and that's Monday at 8:45 a.m. These are capias not in custody for 1 and 2. Is aggravated battery, bodily harm, deadly weapon, and count 2 is possession of a firearm by a convicted felon. I don't have any victims' names or anything. This is actually a warrant to arrest from Judge Shear, and then I see a capia, so. Which one is it, State?
Non-custody capias. It's a non-custody capias on the aggravated battery, possession of firearm or weapon by convicted felon. The felony cannabis, or actually synthetic cannabis over 3 grams, is on an arrest warrant.
Okay. All right, so, State, what say you?
Requesting a $50,000 bond on count 1, a $10,000 bond on count 2. The allegations are that Mr. Thomas attacked the victim from behind, stabbed him, I believe in his abdomen, causing... The laceration to his abdomen required exploratory surgery for internal damage and required 36 staples to close the wound. Your Honor, this was captured with the surveillance. A law enforcement officer familiar with Mr. Thomas reviewed pictures taken from the surveillance and identified Mr. Thomas. The victim also positively identified Mr. Thomas from a photo array. His history: 2014, possession of cocaine with a VOP. 2010, possession of firearm by convicted felon. Resisting with violence, 03, VOP, 15 months state prison. Delivery of cocaine, possession of cocaine, 03 with a VOP, 15 months. Your Honor, I'd be requesting a $1,000 bond on count 3. And should he post these bonds, pretrial release with a GPS monitor level 2.
Okay, defense. Oh, what are you asking for on 3?
1,000.
Mr. Romero, go ahead, sir.
Judge, in speaking with Mr. Thomas, the $61,000 that the state suggests something he's not going to be able to afford. He's 34 years old at this time. He's unemployed. He's looking for work. He lives in Fort Lauderdale. His share of the apartment is about $400. His girlfriend is helping him out right now. She's a server at a restaurant called, I believe, Snappers. She works on hourly and plus tip. So that's the person he's going to be relying on to post his monetary bond. Judge, we're going to be asking you to consider on count 1 a $7,500 bond. We're going to be asking you on 2 to consider a $1,500 bond. And on the cannabis offense, we're going to be asking you to consider an ROR. At this time, Judge, considering, I know the serious nature of the allegations, but Mr. Thomas is looking forward to his day in court to dispute those allegations.
That's not true.
And at this time, we'd be asking you for a total of $8,500, and we wouldn't be objecting to standard pretrial release, Judge.
Okay, court's going to order no victim contact, direct or indirect, with the alleged victim. State. That means no contacts are in person, calling, texting, writing, nothing on social media, nothing through third parties. Do you understand?
Yes, ma'am.
All right, and the alleged victim's initials are?
KJ.
KJ.
Sorry. KJ.
Okay, you're also not to return, sir, to the Quick Stop store at 813 Northwest 27th Avenue. Court is going to do a GPS level 2. As far as bond on count 1, court's going to do $25,000 on 1. Count 2, the court's going to do $7,500, and count 3, the court will do $1,000. Thank you, sir. Good luck to you. It's in Fort Lauderdale, I believe. Is that the city state?
Sorry, Your Honor?
Is the address of the Quick Stop in Fort Lauderdale?
It would appear so, yes, Judge.
All right, and also, sir, one other thing I forgot to say, no firearms, ammunition, or weapons. Do you understand?
Yes, ma'am.
Thank you. Good luck to you. Arthur Kennedy Gates. Okay, Ms. Patrice, on Wold Lubin, it doesn't have no return to this address. Do we need to put it on this order? Yes. That's okay. Okay, Mr. Gates, is that your name, sir?
Huh?
Good morning, sir. Arthur Kennedy Gates? Okay. All right, sir, you have a petty theft, second degree, first offense, $25 bond. You do have a capious felony with a no bond hold. It's actually not for magistrate. He was a no-show, a calendar call before Judge Barbara Duffy.
Judge,
So-
he's not aware of the capias. You know what's the date of the alleged court date he missed?
May
I was there
10th.
on every court date. I just got out on the dead time on the last, came back. That's right.
I'm sorry. What was the court date?
It has here, no-show calendar call. Believe it was May 10th. Can someone tell me, was he in custody? Says throw a deadly missile into vehicle. 2017 case. Ms. Sheila, can you tell me?
She said it's a 2017 case.
2007. I came back to court on. I've been left here about a month ago on that case, that same case.
Can you tell me, Ms. Sheila, when he was in?
He was not in Broward County custody on the
case. I done been here and done time for that.
Even if he was, it's irrelevant. He definitely wasn't in Broward County custody on May 10th.
All right, so court's gonna leave the no bond hold. Why do we have two on Matthew Thomas? Let me just look at this in a second. Hold on. So court's gonna leave the no bond hold in place, Mr. Romero. Let him go to his division judge. He wasn't in Broward County custody. The court does find probable cause. Sir, you can address it, but in the meantime, I'm gonna order no return, sir, to the Walgreens located at
I wasn't at the Walgreens. I was at our casino back in the day.
960 Southwest 26th Ave, Pompano Beach. And the court will leave the $25 bond in place. Thank you, sir. Good luck to you. Okay, Ms. Patrice, on Matthew Thomas, I have two pretrial supervision orders. Didn't I say I was just doing it? Oh, this is for, all right, I'm only gonna do the pretrial supervision on count 1 and 2, not count 3, okay? On Matthew Thomas. Okay, so here you go. Anthony Smith, please.
Mr. Smith is the first judge.
Okay, Mr. Smith, you have a burglary with assault or battery. Court does find probable cause. State.
Your Honor, I spoke with the alleged victim this morning, and I have no objection to the court setting a bond at this time. Your Honor, I am going to be requesting a $15,000 bond an order of no victim contact, and an order that Mr. Smith not be in possession of any firearms, weapons, or ammunition. His criminal history: 2014, sale, delivery of cocaine at Anira Park, 18 months state prison as a habitual offender. 2011, delivery of cocaine, 14 months state prison. 2010, possession of cocaine with intent to sell or distribute.
What was the one before that?
Delivery of cocaine.
Okay.
2010, possession of cocaine with intent, 14 months state prison. 2000, delivery of cocaine, 5 years state prison as a habitual offender. 99, possession of cocaine, 5 years state prison after a VOP. 93, under the name Anthony Watson, possession of cocaine, battery on a law enforcement officer, 4.5 years state prison. 91, aggravated battery against a pregnant victim, 3 years state prison. And I would also just point the court's attention to Mr. Smith's booking sheet and just the number of aliases he has used in the past.
All right, is his address 1150 Northeast 5th Terrace, Apartment 2, Fort Lauderdale?
Yes, ma'am.
All right, sir. Court's going to order no victim contact, direct or indirect, with the alleged victim with the initials LS. Do you understand what that means?
Yes, ma'am.
Okay, and the court's going to order no possession of any firearms, ammunition, or weapons. Go ahead, Mr. Romero.
Judge, if I heard correctly, I believe the state was asking for $15,000.
Yes.
Judge, I don't think we're far off. I was going to be asking for $10,000. This is why. Right now, Mr. Smith is working. He's working for a sprinkler company. Been there for about a couple of years now, making about $100 a day.
What's the name of the sprinkler company?
Roger Dyke Sprinkler.
Okay.
Sprinkler.
Right now, he lives in Fort Lauderdale with his girlfriend. They're sharing an apartment. They have one child in common, an 8-year-old. His girlfriend is the one that's going to be posting his bond. She works at a department store called DD's. He believes that maybe through a bondsman, she can come up with $1,000, and that's why we were going to be asking for a $10,000 bond on count 1, Judge.
All right, this is what the court's going to do. He does have a prior record, and he does have a large amount of aliases. GPS level 2, $10,000 bond. Thank you, sir. Good luck to you.
Judge, we're going to be requesting also a photo order.
Sure. Court will grant your request for a photo order. Johnny, good luck, sir, okay?
Judge, now, Judge, hold on. I know, as he said, he works at a sprinkler company, so basically, depending on the clients, it's not like a schedule that he can give ahead of time. It's depending on his clients. So we're going to ask you then, I guess, maybe his girlfriend can try and come up with $500 more. Judge, just leave.
I'm going to do an open schedule, okay? I have concerns about him returning to court. I'm leaving the GPS on him no matter what, even if I did the $15,000. So GPS, I'll do the open schedule. But I want him to have, give me that back, he's to have a curfew from 8 p.m. at night to 5:30 a.m. in the morning. Thank you, sir. Good luck to you. 10,000, yes. Johnny Dronell Brand, please. I'm 8 p.m. to 5:30 a.m. Okay, Johnny Brand, please.
North Broward, Judge.
Hello, sir. How are you?
Okay.
Sir, you have a retail theft, $300+, second subsequent offense, $3,500 bond. Court does find probable cause. Court's going to order no return, sir, to the Home Depot at 1151 West Copans Road, Pompano Beach, Florida. If you go back there, sir, you will be arrested. Do you understand?
Yes, ma'am.
All right, don't go back there during the pendency of this action or until further order of the court, sir.
Yes, ma'am.
Judge, I'm going to ask for a pretrial release from Mr. Brand, which I imagine the state will have an objection.
Okay, go ahead, State.
Your Honor, I'm going to ask that the court keep the bonds in place. He's out on a $4,000 bond for 2 counts of grand theft, 2 counts of uttering a forged instrument. He also, in 2014, was sentenced to just under 18 months state prison for burglary of a structure and grand theft. He had a criminal mischief.
What year was that?
2014. Criminal
Okay.
mischief 2010, resisting without violence 09, battery 02, arson of a structure early 90s.
Your Honor, Mr. Brand has been a resident of Florida for 43 years. He does have family here, including his sister and his mother. He's been living at the same address for the last 18 years.
The 416 Northwest 2nd Terrace.
Is that your address, Mr.
Deerfield?
Brand?
Sir, you gotta hit the
You
button
gotta hit the button, Mr. Brand. We can't hear you.
This one? Oh, it's on, ma'am.
Okay, we're sorry, I'm sorry, I didn't hear you.
Yes.
Is your address
Yes.
416 Northwest 2nd Terrace, Deerfield?
Yes, ma'am.
Okay. And how long have you lived there?
I've actually been a resident there for 43 years. I was born there.
Okay. All right, my concern, Mr. Reedy, is him going back. This is his 3rd offense, so.
I understand, Judge. On the other hand, from what Mr. Brand has told me, he is not able to post any kind of a financial bond, any type of monetary bond at this time. So I know it's a retail theft. I understand that. He's agreed, I believe, that he will not return to the location where the incident occurred. But he just doesn't have any money, Judge.
Okay, pretrial release, ROR.
Thank you.
Sir, you're not to return to the Home Depot. You get arrested again, and I don't know. Sure, they'll be going to your division judge trying to get your bond revoked. William Huggins, please. Good luck to you, sir. Oh, North Broward Deputy, can you give him a map?
Yes.
Thank you. 1151 West Copans Road, I did say it. If you'd like, I can give you a copy of the order right here. Yeah. 1151 West Copans Road, Pompano Beach. Starting to remember the addresses at these places. Wynnum Huggins, please.
Mr. Huggins is here at Maine.
Okay, Mr. Huggins, good morning, sir. Grand theft.
Good morning.
Grand theft between $300 and $5,000, $1,000 bond. Court does find probable cause. Court is going to order no contact, sir, with Scott Evan Cohen. Do you understand?
Yes.
Did you hear me before say what no contact, direct or indirect means? If you don't, I can repeat what that means, sir, because I want to make sure.
I heard you say it.
Okay, you seemed a little unsure. I just want to make sure you don't violate the court order. All right, sir, so there's no victim contact, direct or indirect. Mr. Romero, anything further?
No, Judge.
Okay, can I see it, please? Okay, this is what the court's going to do. In count 1 and 2, the court is going to revoke his pretrial status. Where does he live?
20 Northwest 42nd Avenue.
I have 2520.
Northwest 42nd Avenue.
2520 Northwest 42nd Avenue, Lauderhill, right?
Right.
All right, so this is what the court's going to do. Was there any bond on this 2013 case?
Judge, my understanding is, I asked you at this time, considering he's been on pretrial from what he's advising me for a couple years, and if pretrial can verify this is his first violation, and he picked up a nonviolent charge, he's presumed innocent at this time, I'd ask you to leave the standard bond on count 1, and on the case that he's out on, not revoke his release.
Okay, can someone answer my question that I asked before Mr. Romero started talking? Was he out on bond?
That court order that I have here that placed him on pretrial supervision, it says defense motion to set aside capias.
All right, pull up this case, Michelle. Let's pull up this case. Give me one moment.
It appears that he was ROR'd to pretrial release August of last year.
Well, he was supposed to do a change of plea. There is. Mm-hmm. All right, so this is what the court's going to do. The court is going to revoke his pretrial, but on counts 1 and 2, I am going to ROR him GPS level 2. And that's in case number 13-13199 CF10A, okay?
And Judge, on his new law offense, then will you also then be placing him on level 2 pretrial in ROR?
Do you want me to?
Yeah, since he's going to be out on level 2.
Okay, who does he live with?
My mom.
What's your mom's number, sir?
954-306-2543.
Your mom owns or leases the residence?
Yes.
All right, what's her name?
Mimos. Mimose.
Okay, and her last name?
As Marcellus. Marllus. Marcellus.
Just so the court's also aware, on the 2013 case, the state had extended an offer to a misdemeanor theft. And I think that's where the case is at this point.
Okay. Well, I ROR'd him, but he did get another charge, so. Okay, so. All right, so you'll have to keep track of this case that his mother, he's going to be living at this address with his mother. I put on the 2013 case, Miss Patrice. I did put the mother's name and address. Thank you. Joan Vieira, please.
Mr. Vieira is approaching, Judge.
Okay, Mr. Vieira, you have burglary of a dwelling structure or conveyance. There's no bond attached to that right now. You have grand theft of a firearm, $1,000 bond. Count 3, grand theft between $300 and $5,000, $1,000 bond. Count 4, you do have a no bond hold, not for magistrate. That's out of Palm Beach County, I believe, sir. Court does find probable cause. Court is going to order no victim contact, direct or indirect, with the alleged victim with the initials LEP. And sir, the court's also going to order no return to 631 Northeast 58th Court in Oakland Park, Florida. Do you understand?
No.
Okay, state.
Your Honor, I'd be seeking a no bond hold on count 1, the punishable by life offense upon a finding of proof evident or presumption great for first appearance purposes only, seeking a no bond hold based on the allegations contained in the probable cause affidavit, but also out of concern that he's currently on probation out of Palm Beach County when committing this alleged offense for an attempted burglary.
All right, sir, I've reviewed the probable cause affidavit filed in your case, and I find probable cause. I further find the proof of guilt to be evident or the presumption great. I'm talking about count 1. Therefore, on count 1, sir, you are going to be held no bond until further order of the court. This order is without prejudice, sir, for you to file a motion to set bond with your assigned division judge and request a hearing under State v. Arthur. The court is also going to order, hold on one moment.
Certainly.
Court is also going to order no firearms, ammunition, no possession of any firearms, ammunition, or weapons, sir. Yes, I'm sorry, Mr.
Yes, Judge. In regard to count 1,
Sure.
the court making a finding of proof.
Sorry, I'm
presumption
sorry.
great. No, that's okay, Judge. In light of the fact that Mr. Vieira is being held no bond on count 4, the violation of probation, we'll defer any argument regarding proof evident presumption great until such time as he can appear in front of his division judge.
All right, and I'm sorry about that. I should have let you go.
That's quite all right, Judge.
Okay. All right, so on counts 2 and 3, court's going to set bond at $999. Anything further from anybody?
Yes, Judge. I have a probable cause argument as to count 2. It appears that the firearm that was removed from the residence was inside of a safe. I don't know if Mr. Vieira can be held accountable for knowing what is inside of the safe that he stole. There's no indication that he ever opened the safe or was aware of the contents therein.
Okay, State.
Your Honor, my understanding is, and unless there's case law, I am familiar with the case law that says you cannot be charged with armed burglary for stealing a safe with a gun in it because it doesn't satisfy the intent argument to arm yourself. However, I do think for just theft, I would argue that there is a certain risk when just stealing a safe, Your Honor, from one's home.
All right, so the court does find probable cause. If you can find case law to the contrary, Mr. Reedy, I'll be more than happy to look at it. Thank you, sir. Good luck to you. $999 on 2 and 3, no bond on 4, and no bond on 1. Kerry Stevens Gaspard, please. Hello, Mr. Gaspard. You have.
Mr. Gaspard is here present, Judge, and he declined to serve as a public defender.
I did not decline. I just wanted to represent myself at this arraignment as far as separating my cases.
Hold on one second, sir. This is not an arraignment. This is first appearance magistrate court. Today is not your trial day, so don't talk about the facts of your case. You're being charged with a very serious crime, sir. And you have the right to have a public defender represent you, even if you just want it for today's hearing.
What I said to the public defender that if I hired him,
you're not going to hire him. He's appointed.
Understood, ma'am. But I was told if I revoke him, that I would plead guilty to all the charges, would have to pay all the court fees and everything else. No, the lady at the desk, that's what she told me.
All right.
And then I also asked the public defender if he could separate the two cases because I wanted to address my traffic and misdemeanor charges and separate the two, if that was possible.
All right, well, right now,
I wanted to comply with the state.
My understanding is, in speaking with Mr. Gaspard, I know he spoke with our interviewer. Question was if he wanted to serve as a public defender. He didn't want to serve as a public defender. I asked him again. He started going into questions as far as can we separate cases. Started going into other matters. I said, do you want the public defender's office to assist you today? He kept on going into giving me different sort of explanations. I don't know if your court is willing to inquire, and if he wants the public defender's office on all these matters, then I'll be more than willing to go ahead and stand up here, Judge, and help him out.
Okay. All right, sir, just listen to me, okay? And just answer the questions, and then I'll give you an opportunity to talk. So, you are charged with burglary with assault or battery. It's a very serious crime, sir. It's a first-degree felony. So, you might want to think real hard, sir, about having the public defender represent you on that charge. If you don't want them representing you on the misdemeanors, we can separate that, and you can give me your argument. You can also have the public defender, just for purposes of today, represent you on the burglary with assault or battery, sir, which currently there's a no bond hold, or You can either represent yourself on the misdemeanors, or you can have the public defender, just for purposes of today, represent you on all the charges. So keeping that in mind, and I can't resolve any of the cases. The misdemeanor cases are separate, sir, anyway, as far as I see, because it's for possession of cannabis. It has a 2017 case. Refusal to sign citation, that's part of the possession of cannabis. You have failure to register a vehicle, that's part of the, no, that's, yep, that's the same case number. And then unlawful license tag sticker attached, that's part of case number 17-1041, 10414, MM10A. So those last four charges, starting with the possession of cannabis and on, are a different case number. And those are capiouses. We can talk about them separately. But the case that really is the most important to talk about, sir, is the burglary with assault or battery. So what would you like to do?
I'm going to take the public defender on that one.
Okay. On which one? The battery?
Yes, ma'am.
All right. What about on the capious misdemeanors, just for purposes of today?
Can I tell you what happened?
Well, you're not, if you talk
I
about,
appeared in court as far as the capious warrants goes, but I kind of made Judge Christopher Pohl upset because I was saying things like, I would like the case dismissed for lack of a sworn complaint by an injured party, and there was no injured party present. He told me if I didn't hold my tongue, he would hold me in 30 days of contempt of court. I told him that, well, your constitutional rights can't be turned into a crime, Your Honor. I was just asking a simple question. And he just threw me out of the courtroom, and I tried to go back. I tried to turn myself in. I got tickets. Nobody booked me. And the incident happened with the battery and assault.
Don't talk about the facts.
Yeah.
I'm on that. Don't talk about the facts.
all right, so sir, let's go ahead and let's go forward. Let me just tell you what you're charged with. And Mr. Romero can represent you on the assault or burglary with assault or battery today. And then we can talk about the misdemeanor cases, okay? The capiouses.
Okay.
So, and I'm going to go through all the charges just to make it clear. You have burglary with assault or battery. There's no bond attached to it. We need to talk about bond. Count 2, 3, and 4, and 5 are the capious misdemeanors, and the judge did issue a no bond hold. You do have a court date coming up this Tuesday, sir, June 5th, before Judge Pohl at 9 a.m., okay? So, court is going to order no victim contact, direct or indirect, with the alleged victim in the case with the initials JC. Do you understand that, sir?
Yes, ma'am.
All right. So, and did you hear me before say what direct or indirect means? Do you understand that?
One more time.
Did you hear? All right. No contact, direct or indirect, means no contact in person, calling, texting, writing, nothing on social media, and no contact through third parties, okay?
Yes, ma'am.
All right, State, what are you asking for on count 1?
All right, Your Honor, on count 1, punishable by life offense, the state is not going to be seeking a no bond hold. I'm going to be requesting a $20,000 bond, pretrial release with a GPS monitor, no victim contact, additionally in order of no firearms, weapons, or ammunition. I spoke with the alleged victim this morning. While she has no objection to Mr. Gaspard receiving a bond, she does have concerns for her safety. She does know him. She has, as you can see, she was with his mother at the time of the alleged incident. She does have a reason to believe that he does possess firearms, and so she has a concern about that. Your Honor, I'm requesting the GPS monitor because of my concern about his future appearance in court. Your Honor, I received information from the assigned prosecutor to his case before Judge Pohl. And the information I received is, on February 6th of this year, he was set for jury trial. He did come into court. Judge Pohl attempted to ask him some questions. Mr. Gaspard refused to answer his questions, read a writ that he had brought to open court, and Judge called for deputies. And as soon as Mr. Gaspard finished reading, he vacated the courtroom. Deputies did not get to the courtroom in time before Mr. Gaspard left. So Judge Pohl issued this no bond plea.
Okay, can you talk a little bit louder because I want to make sure he hears you.
Your Honor,
Sir, don't talk about the facts of the case, okay? Just
I wasn't speaking about the facts, ma'am. I'm not disrespecting you.
What did you hear up to?
I was speaking to my lawyer, so I only heard up to the portion where he said, Christopher Poole, I wasn't listening. I'm sorry.
Okay, so start from the point that he came for jury trial. I just want to make sure Mr. Gaspard understands and heard you.
The case was called. Judge Pohl attempted to ask Mr. Gaspard some questions. Mr. Gaspard refused to answer any of these questions and proceeded to read what's referred to as a writ that he brought to court. Judge Pohl called for deputies to come to the courtroom. Mr. Gaspard finished reading whatever he brought to the courtroom and proceeded to walk out of the courtroom. And he did this before deputies arrived. And apparently Mr. Gaspard left the courthouse. It was at that point that Judge Pohl issued the no bond capias.
Okay, Mr. Romero, what say you?
Judge, in reference, like I said, we're representing him on count one. I believe, if I heard correctly, the state is not seeking to have the court make a finding of proof evident presumption great. And I believe the state has asked for a $25,000 bond. Is
20.
that correct? Oh, $20,000 bond. All right. If I can have then a couple more seconds to speak with Mr. Gaspard about the monetary bond. Okay?
Sure, go ahead. I'm writing down. You got the mother's name and number on Johnny Brand?
Judge, we're ready to proceed on count one as far as the monetary bond.
Scan all of our orders in together, so when they go in together.
I just wanted to make sure so there's not a delay. Okay, so Michelle, do me a favor. Can you make a copy of this? Yes, ma'am. Thank you. Okay. So let me ask you to do something when I go away. All right, go ahead, Mr. Romero. I'm sorry.
Judge, in reference to count one, basically in speaking Mr. Gaspard, the $20,000 bond is something that he nor his mother are going to be able to post on his behalf. He's 27 years old, been living in our community for a number of years now. He's right now working. He works for a company called All Star Event Company. It's a full service party planning event company.
Okay.
He makes, depending on the season, on a high season, he make upward to about $500 a week. On a low season, about $200 a week. So it really does fluctuate. He's going to be depending on his mother to help post his monetary bond. His mother, from what he informed me, works like at a call center, making on an average about $10 an hour. So $20,000 is going to be out of reach for him or his family. We're going to be asking you on count one to consider setting a bond of $2,000. Besides his expenses, Judge, as far as living expenses, he also pays back student loans. So that's something that he has to account for, and that's something that makes his financial resources even less. And that is the reason why we're going to be asking for a $2,000 bond on count one.
Where's he going to be living?
Judge, my understanding is going to be living with his mother in West Park.
I have an address here. It's 3121 Southwest
That's your address?
32nd
That's
Ave,
where
but
your
it
mom
says
is?
Hollywood.
Okay. Oh, Hollywood. Is it Hollywood or
West Park and Hollywood is
The same?
kind of. Yes, ma'am.
All right, I didn't know that. I'm sorry, sir. All right, so they do have the right address down. All right, so let's get to 2, 3, 4, and 5. You want the
And
public
that's the
defender
case
to
that I'm
represent
not
you
on,
on
Judge.
them?
No.
You want the public defender to represent you on those for today?
I wanted to hear what the state was offering before I.
Okay, there's no offer by the state. All there are 4 cases, and actually there's no bond holds. Unless you were incarcerated at that time, it's Judge Poll's order, you failed to appear for jury trial.
I was
It's
incarcerated, ma'am.
Out of the courtroom.
You walked out of the courtroom though.
But I was incarcerated before that.
All right, but that doesn't matter. It's just, let me tell you how this works, sir, okay? Just so you understand. So when there's a capias and it says defendant no-show, which means you voluntarily left, so they consider it as a no-show, even though you were there, you left too early. The judge signed a no bond hold, so the court is going to honor that. So unless you were in custody on that date in another courtroom or the jail didn't bring you over, the court would keep those, would not keep the no bond hold obviously in place. I would contact Judge Poll. But since Judge Poll did sign this and you left earlier, the court is going to have to keep those no bond holds in place. However, you can go before Judge, you're going to go this Tuesday before Judge Poll.
He's going to murder me.
He's not going to murder you, sir.
Yeah. He's going to, I
Okay,
disrespected his court.
All right, so this is what you might want to think about, sir. If you can't afford a private attorney, then what you might want to do is consider seeking the assistance of the public defender, okay?
And there's no way the state can resolve this right now if I paid court costs or took a course, whatever they're offering, nothing?
Well, it's possession of cannabis, failure to refusal to sign citation, failure to register a vehicle, and unlawful license tag sticker attached.
Your Honor, considering this case was set for jury trial, I do not have an offer at this time.
And all right, give me one moment, sir, okay?
Yes, ma'am.
Your Honor, I just, while you were making that call, I spoke with Ms. Grant from my office again, and she provided me with some additional information again, telling me what she described this to be a very hostile situation in the courtroom at the time. To the
Are you
going so
talking
far
on
as
count two?
I'm talking about the case in front of Judge
Misdemeanors?
Paul. Yes.
Okay.
Going so far as to advise me that Mr. Gaspard, he took physically stepped towards her in a hostile nature during the hearing that morning, Your Honor. And now being told that, seeing these allegations before the court, I am asking the court to take no action as far as.
All right, well, I put in a call. This is what I'm gonna do. I'm willing to rule, or I can wait on the burglary with assault or battery, and I really, you know what, now that I think about it, let's wait. I called Judge Pohl. He's up teaching at Judicial College. I know they take a break at 1 o'clock. I left him a message. He'll call me back. Court's considering taking an open plea. However, you're gonna have to talk to him about points and stuff like that with this charge that he's charged with. So let's reset Mr. Gaspard for 1 p.m. today. Thank you for your patience, sir, okay?
Appreciate that, Your Honor.
You're welcome.
You'll be back at 1 o'clock.
Devontae Holiday? 12 o'clock, we're cutting it off, folks. Devontae Holiday. All right, sir, you have a grand theft auto, $1,000 bond. Count 2 is operating without a valid DL. Court does find probable cause. Court's going to order no victim contact, direct or indirect, with the alleged victim with the initials SI. Do you understand, sir?
Yes, ma'am.
All right. Mr. Romero, $1,000 bond. Can you afford it?
No, Judge, we're going to be asking for pretrial, see if the state has an objection.
State? While the state's looking, is his address 3551 Northwest 9th Court, Lauderhill?
Is that your address, sir? That's my mother's address.
Okay. Is that where you're going to be getting
Get
mail?
there, right? Yes, ma'am.
Is that where you want to get mail?
Yes, ma'am.
Okay.
I don't have an objection to pretrial.
Okay, standard pretrial release. Sir, you have to report within 24 hours. Okay? You have to report within 24 hours. I don't know if you're going to get there out by 3 p.m. today. They're open till 4. You have to get there by 3. If not, you have to show up there tomorrow by 12 noon. You understand? You want to explain it to him, Mr. Romero? Thank you.
Yes, ma'am. Yes, ma'am. I understand.
All right, Keith LaShun Taylor, please.
Mr. Taylor's here present, Judge. Can you kindly start the public?
Okay.
No, I had a time thing, and that's for court.
Okay, hello. All right, sir, you have counts 1 and 2, possession of weapon or ammo by a convicted Florida felon. State's going to be requesting a bond. Count 3 is carrying concealed firearm, $1,000 bond. Count 4 is a capious felony. You have a no bond hold. Actually, that's not for magistrate. I'm just letting you know you have a no bond hold. And 5, 6, 7, and 8, and 9, the second page, are all well, I'm sorry, 5, 6, 7, and 8 are out of county holds for felony. You have no bond holds, whoever the division judge is there. And then count 9, you do have an out-of-state hold for a felony. You have a no bond hold. Court does find probable cause. You will be coming to extradition court Tuesdays or Thursdays at 1 p.m. So we have to, hold on one moment. So we have to talk about bond on counts 1 and 2. State, what are you going to be asking for?
Considering the cases he's out on, including but not limited to an aggravated assault on a law enforcement officer.
Okay.
$10,000 bond on count 1 and 2.
Okay. Someone was going to say something from pretrial, I believe?
No, that was me, Judge. I was just advising that,
He has pending cases?
5 through 8 is Hillsborough.
Oh, 5 through 8 is Hillsborough County, the Addis County holds, okay? Hello. How are you? Good. All right, and count 9, the out-of-state hold, is that a where? Does anybody know? North Carolina, violation of probation. So, anybody want to be heard, Mr. Romero, on counts 1 or 2, $10,000 each, and $1,000
Judge, that's
on
something
3?
he's not going to be able to afford, Judge. We're going to be asking for a $1,000 bond on count 1, $1,000 bond on count 2. He's lived here his whole life. He works for AAA Installations. He makes about $500 a week. Judge, I do understand he has a no bond hold. on count 4 and 5 through 9. So, Judge, I'm going to be asking for $1,000 bond on count 1 and 2.
All right, so this is what the court's gonna do, $24.99 on 1, $24.99 on 2. Count 3 is gonna be $99. Any special conditions, state, anything?
No, Judge.
All right, thank you very much, sir. Good luck to you. Danielle Dunkelberger, please.
And I'm going to be asking for pretrial release on this case, Judge.
All right. Mr. Dunkelberger, how are you, sir?
I'm good, Judge. How are you?
Fine, thanks. You have burglary, unoccupied conveyance, unarmed. We need to talk about bond. Count 2 is resisting an officer, obstructing without violence. It's basically an ROR. The court does find probable cause. Court is going to order, sir, no victim contact, direct or indirect, with the alleged victim with the initials NAG. What no victim contact, direct or indirect means, sir, is no contact in person, calling, texting, writing, anything on social media, and no contact through third parties. You understand?
Yes, ma'am.
All right. All right, State, what are you requesting on count 1 and any other special conditions?
$3,500 bond on count 1. Would be objecting to pretrial release, Your Honor. He just got arrested last month for a failure to appear. That was on defrauding an innkeeper. 2014 DUI. 2012 obtaining controlled substance by fraud, VOP, just over a year state prison. 09 aggravated assault with a deadly weapon, battery, criminal mischief, unlawful use of false name ID. VOP, 18 months state prison. 09 unlawful use of false name ID. 09 burglary of a conveyance, VOP, 18 months state prison. 09 failure to leave property upon order from owner, and a theft in 08.
Okay.
Your Honor, Mr. Dunkelberger has been living here in South Florida his entire life. He has extensive family here, including his mother, his father, a lot of other family members, including his wife and his 7-year-old daughter. He's been living at the same location for the last 4 years. He receives disability, and that is why he is unable to work. There are other factors at play here involving the incident involving Mr. Dunkelberger and the police in this particular case. That's why a monetary bond is going to be extremely difficult for his family. He gets a check at the end of every month. It's not a check for very much, and that's his only source of income. I would ask the court to consider pretrial release with a GPS monitor so that we know where he is at all times. This will allow him to...
Let me verify his address, 410 Southwest 9th Ave, Apartment E, Hallandale.
Yes, ma'am.
Who do you live there with, sir?
I stay with my father, my mother, and my brother.
Okay, whose name is do they own or lease?
They lease.
Okay, and who's the person that's on the lease?
My father, Robert Pitticelli.
Okay, hold on one moment, sir. I have to take a call about another case. Hold on. And Ms. Jackson, make sure that cover sheet stays there, because I need my notes for that, okay? On that gentleman. Okay, I'm sorry. Pardon? Okay, well, Dante did one time, but whatever. Okay, Daniel James Dunkelberger?
Yes, ma'am.
All right, I'm sorry, I had to take another call. So, you're requiring just level 2 GPS, and you were telling me, I'm sorry, sir, I just
My
forgot
father,
where we were at. What's your father's name?
Robert Pizzocelli.
And it's his father's name is not the one on the lease where he would be
Okay,
living.
give me the, last spelling of your father's last name, sir.
Pitoccelli.
Okay, and what's his number, sir?
954
Okay.
793 5035.
5035. Okay, so this is what the court is going to do. State, you were requesting, was it $3,500? All right. And you're saying he can't afford any bond, even $100, if I did a $1,000 bond?
$100 would be difficult when he is on this fixed income, Judge.
But what about his
disability.
family?
No, ma'am.
I don't know about his family. I know that Mr. Dunkelberger it would ultimately be responsible
Okay,
for whatever bond is
GPS
posted.
level 2 ROR.
Keep an eye out for your court dates, Daniel. Do not miss court.
Yes, sir. Yes, the one that I had the failure to appear.
Don't talk about any of that right now. You're getting
Sir,
released.
you're getting out, so.
Thank you, ma'am.
Your
Thank you so
father is
much.
going to be getting a phone call. He has to pick up the phone.
Okay.
Pretrial services, make a copy, Michelle. Okay, they're going to be calling him, verifying you can live with them. GPS level 2, good luck to you.
Thank you.
Andre Williams Higgs.
Mr. Higgs is approaching, Judge. He's here at Maine.
All right, Mr. Higgs, how are you,
We waive
sir?
reading of the charges, Judge.
Okay, I gathered. All right, sir. Counts 1 through 4, sir, they're waiving reading. Count 5 is probation violation. You have a no bond hold. The court does find probable cause. Court's going to order no victim contact, direct or indirect, with the alleged victim with the initials HL and HL's family. Do you understand, sir?
Yes. Yes.
All right, no contact, direct or indirect, means no calling, no in-person, texting, anything on social media, even liking, disliking anything, commenting, and no contact through third parties. Do you understand, sir?
Yes.
All right, state any other special conditions.
No contact with minors, Your Honor. And I'm going to be requesting pretrial release of the GPS monitor level 2. I'm also going to be requesting, based on the allegations, a $25,000 bond per count.
I'm sorry, GPS level 2.
Yes.
And what was the last one?
$25,000 bond per count.
Okay, go ahead, Mr. Romero and Mr. Reedy.
Judge, in speaking to Mr. Higgs, he's been here in South Florida his whole entire life. At this time, he's advised me he has big plans. He wants to go back to school. He wants to study sports management. He's also looking for work. At this time, he's not employed. He lives in Dania with his father. He's going to be contacting his father to hopefully help have him post his bond. But from what he informed me, he really doesn't think his father can afford that much. He doesn't really know how much his father makes. But Judge, I'd ask you to take that into consideration, determining a reasonable bond. I do understand on count 5 he's being held no bond. My understanding is from what he's advised me, he's been on probation for a number of years. And I believe he's only violated one time with the cannabis offense, Judge. So he's been trying to adhere to his supervision. Judge, we'd be asking you to consider setting on count 1 somewhere in the neighborhood of $2,500. I believe the total then with 1 through 4 would be a $10,000 bond. We'd have at this time no objection to pretrial release. But unfortunately, that's all Mr. Higgs is going to be able to afford. And I don't even know if his father will be able to afford that, Judge.
All right, he has a no bond hold. So this is what the court's gonna do. No victim contact, direct or indirect, with HL and HL's family. No contact with any minors less than 18 years of age, obviously. GPS level 2. Court's gonna do $25,000 on count 1, $10,000 on count 2, $10,000 on count 3, $10,000 on count 4. Count 5 is gonna be a no bond hold. Thank you, sir. Good luck to you. Does anybody know when he's going before his division judge, or is that somewhere else? That's Highlands County, sir. Good luck to you.
Different county.
Yeah, thank you. Okay, Stephen, Jane, Jatav, Virgil.
Mr. Virgil is approaching, Judge.
Okay. Hello, Mr. Virgil. How are you?
Hello, good morning.
You have manufacture, distribute, sell, etc., imitation drugs, $750 bond. Count 2 is a probation violation. You have a no bond hold. You are going before your division judge, who is Michael Lynch, on June 5th, which is this coming Tuesday at 9 a.m., sir. Count 3 is possession of cocaine, $1,000 bond. Count 4 is resisting an officer or obstructing without violence. It's basically ROR. You do have a no bond hold on count 5 as well, which is a probation violation. Court does find probable cause. Anybody wish to be heard?
Judge, considering it's no bond hold, at this time we'd defer any argument, but we'd be asking you to sign a photo order.
Okay, the court will sign a photo order, $749 on 1. Count 3 is $999. Next one is Angel Figueroa.
Mr. Figueroa is approaching, Judge.
Okay, bonds posted. Thank you.
Good luck, sir.
Next one is Christine Fraguda Cortez. Okay, and then after that we have Jamal Ajani Smart.
Mr. Fraguada is here present, Judge.
Okay. Did Mr. Romero say your name right, sir?
Yeah, well, that's everyone have that struggle with the last name. I understand that.
Okay. All right, sir, you have retail theft, $300+ coordinate with others, $1,000 bond. Court does find probable cause. Court is going to order no return to the marshals at 1401 South Federal Highway, Pompano Beach. Do you understand, sir?
Yes, ma'am.
All right, if you do go back there, sir, you will be arrested. So don't go back to the marshals. 1401 South Federal Highway, Pompano Beach, Florida. Anybody wish to be heard? Can he afford the $1,000 bond?
Yes, Judge, we're just going to ask for a phone order.
Okay, so the court will do a phone order. If there's an issue with bond, let me know. Thank you, sir. Good luck to you.
Thank you.
Jamal Ajani Smart, please.
North Broward.
Okay, and then we have Chadrick Lofton. Pardon? No. Oh, wait, I do. But it says Calvin Johnson bonded. I have, is that correct?
Is here present, Judge. Calvin. Mr. Johnson.
Well, which
Judge,
is this
I believe
one?
he's being held no bond on count 2 and
All right, so let me just verify, because Michelle just wrote bonded on it. Angel Figueroa, is that the one that bonded?
Yes.
Okay, so who do you have standing there, Mr. Romero?
Mr. Calvin Johnson.
All right, come on up, Mr. Johnson. We'll take your case quickly. Mr. Johnson, you have resisting an officer without violence, $100 bond. You do have a probation violation. You are going to court in front of your division judge, who is Judge Tim Bailey, this Monday at 9 a.m., which is June 4th. You want to go talk to him? Okay, June 4th, sir, at 9 a.m. Anybody wish to be heard?
Judge, considering as a no bond, we'll ask for a dollar bond.
Dollar bond on count 1. Thank you, sir. Good luck to you. You'll see your judge on Monday, okay? Chadrick Lofton, where is he? Anybody left there, Mr. Romero?
Nobody, Judge.
See you around 1:15.
Thank you, Judge.
Thank you. All right, Chadrick Lofton, or what's your name, sir?
Jamal Smart.
Are you Mr. Smart? Hello, how are you, sir?
Doing all right, ma'am.
All right. Okay, sir, you have counts 1 through 10. Possession of weapon or ammo by a convicted Florida felon. We need to talk about bond. Count 11 is possession of cocaine, $1,000 bond. Count 12 is trespass, armed structure, or conveyance, $1,500 bond. And count 3, sir, is the no bond hold. And I believe that's an out-of-county one, correct?
No, it's Broward.
It is Broward? Okay, you have a no bond hold for Broward. And then you actually, it does have on the third page, you are going before your division judge on that, Judge Barbara Duffy, this Monday at 9 a.m. Count 14 is the same thing, probation violation, no bond hold, June 4th, Judge Duffy. And count 15 is leaving the scene of a crash involving damage to property, $100 bond. Court does find probable cause. Anybody wish to be heard?
Your Honor, based on the fact that he was placed on probation just over 3 months ago for burglary of a dwelling by Judge Duffy, and that also involved a grand theft, I'm requesting a $10,000 bond on count 1, a $5,000 bond on count 2. I have no objection to an ROR on counts 3 through 10.
That's what I was going to ask as far as counts 3 through 10 are concerned. I think it's one of these situations where they charge Mr. Smart
for each bullet or
for
something?
every bullet, right?
Yeah.
He has a no bond hold, Judge. He really doesn't have any source of income at this point in time. I don't believe he's going to be able to make any kind of monetary bond. I think what the state is asking for is a little high. I'd ask the court to consider a $1,000 bond on count 1 and count 2.
All right, this is what the court will do. $7,500 on 1. I'll do $6,000 on 2. 3, 4, 5, 6, 7, and 8. The court will ROR. So this is 4, 5, 6, 7, 8.
Yeah.
1, 2, 3, 4, 5. So counts 3, 4, 5, 6, 7, 8 are ROR. Count 9 is ROR. Count 10 is ROR. Count 11 is $999. Count 12. Court will make $1,400. And count 13 is obviously a no bond hold. Count 14 is a no bond hold. Any objection to $1 bond on Mr.
No, Your Honor.
Okay, I'll do a $1 on count 15. Does everybody have that? You need me to repeat that, Miss Sheila? You got it? Okay. All right, sir. Thank you. Good luck to you.
Good luck, Jamal.
All right, we have one person left, Chadrick Lofton. Does anybody know where he is?
Judge, he was here at Maine. My understanding in speaking to the deputy, he was staying in the courtroom 6750, so he's not here at Maine.
Probably being arraigned on these charges.
Who's 6750? That's FC. Judge Howery. All right. Hold on one moment. Does anybody know if he's being housed at the main jail?
Hello, you have reached the office of the Honorable William W. Howery Jr.
All right, well,
presiding over
let's
criminal
see if we
division
can get him.
C.
Pardon? Does anybody know if he's at the main jail or?
Judge, he's at Maine. You could reset him for the PM.
All right, let's reset him for the PM. So have him reset him for the PM, okay? Thank you.
PM.
Unless you want to do it tomorrow, it doesn't matter to me.
It might be better, Judge, tomorrow, because we don't know if we'll even be able to bring him. That's the indication I'm bringing. His hard card, his paperwork, or something like that, Judge.
All right, fine, we'll reset him for tomorrow. Thank you. See you in a bit.